behalf of the petitioner has drawn the attention of this court to the office memorandum dated 6/9/2023, wherein it has been mentioned that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. The learned counsel for the petitioner therefore submits that as the petitioner had rendered more than 30 years of continuous service, he would be entitled to pension in terms with the office pensionary benefit in terms with the office memorandum dated 6/9/2003. On the other hand, Mr. R. Borpuzari, the learned counsel appearing on behalf of the Finance Department, relying on paragraph number 23 of the judgment in the case of Upenda Supra, had submitted that the division bench of this court, while granting or while directing that the casual employees appointed to non-sanctioned posts, though would be entitled to the minimum of scale of pay, but they would not be entitled to any consequential benefits, including pension. Mr. I. Saikya, the learned counsel appearing on behalf of the petitioner, however, submits that the judgment rendered in the case of Upenda Supra was a case pertaining to regularization, which the division bench of this court negated the same, however, directed that those persons who have been working for more than 10 years with effect from the state judgment, prior to the state judgment, prior to 1/6/2017, would be entitled to the minimum of the scale of pay. The learned counsel for the petitioner further submitted that the office memorandum dated 6/9/2003 was never before the division bench, was never an issue before the division bench, nor there was any adjudication as regards the entitlement of the pension. And as such, he had submitted that the judgment rendered in the case of Upenda Supra, insofar as the direction, so far as the observation that the said persons would not be entitled to consequential benefits, including pension, would not be binding, would not be a binding precedent in view of the rule of sub silentio. The respondents are directed to the respondents are directed to file their affidavits by 8th of May 2023, so that this court is in a position to take up the matter on 10th of May 2023, as already fixed here in above. Develop your argument. I've made the basis.
I know to
Deeply applied.
My lord,
Yes.
this is the case of non-payment of salary.
Huh?
Non-payment of salary.
Non-payment of salary. For which period? Or you have not got a single penny till now?
No, not
This is the area salary, my lord.
area salary.
Which period?
Period is
The
monthly salary.
petition starts and finishes so soon. Very difficult. You are entitled to 10,47,000.
Yes,
Gratuity, area pending,
area
leave
pending.
encashment.
Gratuity.
Yes, Mr. Dor,
No, my lord,
why is such stepmotherly treatment to this petition?
my lord, this pertains to that corporation. Plain State
Oh.
Corporation. I do not know, my lord, his name is not reflected in the cause list. On the last occasion, there are the
Did you
direction
serve a copy, Mr. Counsel?
Yeah, already we have.
To whom?
3 and 4.
No.
These 3 and 4 are the main respondent, my lord.
Will issue notice then?
Let notice go, my lord.
No pity. You have the receipt?
In mobile.
Oh, very well. We are still to go to e-court. Yes. Heard, Mr. M.H. Ali.
What
is your name?
P.
P. Dekar. The learned counsel appearing on behalf of the petitioner. Mr.
I am appearing for 1 and 2, my lord.
Ardhor appears for respondent number 1 and 2. Issue notice making it returnable on 19th of May 2023. As Mr. Ardhor represents the respondent number 1 and 2, extra copies of the writ petition be served upon him by 12/4/2023. As regards the respondent number 3 and 4, the petitioner is directed to take steps by way of registered as well as usual by 12/4/2023. Further to that, the petitioner is also directed to take steps by way of dusty, routed through the registry of this court, and file an affidavit of service on or before the next date. The claim of the petitioner herein is that the petitioner have rendered service in the Assam Plain Tribes Development Corporation Limited and have retired. There is an area salary. The petitioner claims to be entitled to gratuity, area salary, as well as leave encashment, totaling to rupees 10,47,876. The respondents, more particularly the respondent number 3 and 4, is directed to apprise this court on the returnable date as regards the entitlement of the petitioner, and if the petitioner is otherwise entitled to, as to when the said amount shall be paid. Yes, accordingly.
My lord, then my name will be shown in the cause list, my lord. SCTA, tribal affairs, my lord.
Mr. The registry is directed to show the name of Mr. Ardhor representing the respondent number 1. But Mr. Ardhor, do something. That particular corporation is always not represented. Ask your people out there in your department that something has to be done. If nothing is done, then what is if the corporation under the government is not represented? What is wrong with the corporation?
My lord will observe this. I will take it up with the principal secretary, my lord. Just,
every time this is happening.
my lord,
All matters.
my lord,
No, there are many other. In this case, I am not, because his name is otherwise upfront. But
yes.
there are in many
On the
other
last
cases,
occasion, my lord
I
has
have recorded out there that you
Through-
want in those
police
cases you have
commissioner.
appeared.
in
Just check one of the orders, you will find that in spite of service being given, meted out to the standing council has not presented. Something needs to be done. It is after a government corporation. And if you are having a standing council, if the standing council does not represent, it portrays a very poor picture. Do something. Tell your officials out there to talk with your managing director.
I will.
Yes, madam.
Yes, Lordship, and please, your Lordship, last petition, Lordship, I filed the pension payment order, Lordship, that has not been tagged,
Hmm?
Lordship, on last petition, I filed an additional affidavit,
Hmm.
which is bringing on the record of pension payment order, Lordship,
Yes.
that has not been tagged, Lordship.
What was your case? Last time you sought to withdraw, now you have already received something, no?
Yes, yes, your
You
Lordship,
are now receiving the family pension.
yes, yes, Lordship,
Earlier period, that is an area you are entitled to.
yes, Lordship, from the date of retirement.
Which
that-
period?
From 2011, 30,
The
31,
date of retirement.
31,
Problem is your prayer. Calling upon so called why there shall not be the area pension of the petitioner forfeit with effect from the date of retirement. Till when?
4/12/2018.
4/12/2018. Where have you mentioned? In your petition, you said on the last time, you have mentioned in a particular paragraph
Yes,
that you have
Lordship,
received.
paragraph
Yes,
number
yeah, paragraph 13.
Yes, Lord.
Yes. Isn't it?
Yes, Lord.
Heard Miss M. Nirola, the learned counsel appearing on behalf of the petitioner. Mr. You are PWD this time,
My
Mr.
lord,
Adhar?
my lord.
Mr. Adhar appears on behalf of respondent number 1,
1 to 5, my lord.
2, 3, 4, 5. Where is you are for? Who is appearing for government? Mr. T. Bora appears on behalf of the respondent number 6. Miss
A. Lala for
A.
respondent.
Lala appears on behalf of respondent number 7. Issue notice making it returnable on 17th of May 2023. As the respondents are duly represented, extra copies of the petition be served by on or before 12th of April 2023. The issue involved in the instant writ petition is that the petitioner herein, who is the wife of late Inodhar Hazarika, have not received the family pension for a period from when did your husband die?
5/1/19, Lordship.
Huh?
On 2019, Lordship.
When did you start getting your family pension? You are asking for areas of the pension,
Areas.
no, not the family
Not,
pension.
Lordship.
So you have received from 4/12/2018.
Yes.
Who got it?
Wife of the Lordship is petitioner, Lord. Wife of the Mr. Dinadhar Hazard.
No. Your husband died when?
5/1/19.
19. Then obviously she couldn't get the family pension. A family pension will start after the death.
After 2019, yes, Lordship.
So this is only for the period from 31/5/2011 to 3/12/2018.
Yes, Lordship.
This is the pension.
Yes, Lordship.
The case of the petitioner herein is that the husband of the petitioner during his lifetime did not receive the area pension for the period from 31/5/2000 from 1/6/2011 to 3/12/2018. The respondents on the returnable date shall apprise this court as to why the said amount, the area pension, why the husband of the petitioner was not paid the area pension, the pension for the period from 1/6/2011 to 3/12/2018. Liberty is given to the petitioner to mention the matter for upgrading.
4.
Yes, Mr. Sharma. What is this? So many people.
Yes, sir. PRI institutional.
Oh, PRI.
Yes, my lordship.
But that day I passed an order. So it will be same. It was the order of the last fix. Last was fix or item number 4. Huh? Same order. Dispose.
Lordship decision has acted as a beacon light for them.
Huh?
Lordship decision is acting as a beacon light for them.
Why?
More and more cases are coming.
Only now 34 districts are left. 34 districts are left still.
34 districts are
The Sailubu, huh? Your district is which?
Nalbari.
Nalbari. That one was Gwalpara.
Gwalpara and Borpeta.
One more.
The only thing is you have to come within the ambit of the 182 crores.
My lord, another matter, Walpada is also pending now in motion in court number 3, 4.
Anyways, he dispose of, huh? Because file book. Or Mr. R.P. Sharma, the senior counsel, assisted by
Devashish Dole.
N.K. Devnath, PNRD. You're there? Mr. Ardhar, yes, for the state of Assam, Mr. R. Secretary.
5,
Dispose, huh? Mr. Borbuzari, in this case, earlier, Mr. Sharma, I had, as per your insistence, I said that a copy of that order of that, it is otherwise a 500-page certified copy.
No, I have certainly.
Huh?
So those names I have removed only the relevant. The judgment is there.
You got it?
Yes.
You have to give a copy out there. That judgment.
Yes.
You have to give.
It is on it.
That is the order.
Yes.
That you will also, apart from that, your claims and all, you will also serve a copy of this order.
This is the initial order of my lord.
Oh, that one.
That
That
one.
Noli Bosumatari, something, what is his name?
Judgment is a whole issue.
That 500 pages, yes. What is the name? The top one?
My lord, Poli Nagwangsi.
That Pauline
WPC 36621 of 2018.
Yeah.
Because all the extensive reasoning is to be founded in my lord's that earlier judgment, the first one.
Yes.
So these are my lord of
Because I am quoting only paragraph 39 to
no
42.
difficulty.
39 to 43.
42. Yes, what is this case about?
Oh, my lord, petitioner's husband died in harness, and thereafter she was given AIS money and leave salary, and also professional compassionate family pension for 3 months, and then the processing of pension papers was stopped. And application for final withdrawal of provident fund was returned, and the provisional family pension was also stopped.
Now your compassion, when was he supposed to retire?
Um, 2007.
You are the wife or who?
Oh, right.
Wife.
Yeah.
Wife. Your husband was supposed to retire when?
31/8/2027.
Huh?
27.
31/8/2027.
My
10/6/1992 date of birth. Who? Date of birth. What is his name? Why? What is this annexure 1C?
1.
What is this document?
1.
1C.
It's
Page 33.
It's a birth certificate of,
Of?
if it's a birth certificate of my son.
Of?
My son. My petitioner's son.
Son.
Yes.
Okay. And he was born in 1992.
My lord.
And when did he enter into the service?
My lord, kindly come to page 40, which there is the details.
Page
40, 40.
40.
40.
Yes.
This
What
is
is this?
petitioner's husband, Salim Muhammad Portuya, Hindi teacher.
No.
And the date of birth is there, date of joining, and date of death. 25.
Salim Ahmed Bolbhuya.
Yes.
He was born in 1967.
Yes.
Date of joining is 1994. Date of retirement is 2022.
Date of death.
Huh?
Date of death.
Date of retirement it is given.
Yes, but within bracket there is expired.
Okay. What is the date of retirement?
Date of retirement is at page, my lord, which is the,
We can find it from 67. It is 60 years, no?
yes,
Then it is 2027.
yes, 2027.
Now you have been getting some.
31/8/2027 is the
You,
date of retirement.
you got some
Yes,
compassionate family pension. You got
pension
it
for 3 months.
for 3
For
months,
3 months.
and thereafter they stopped.
They stopped.
That is why you are before this court.
Yes, yes, my lord.
Very
The communication at page
Okay.
57.
Have they informed you why they have stopped?
Yes, at page 57. my lord.
Page 20,
57.
57. Yes.
57.
With reference that the honor to include the complaint petition is submitted by Hafida Begum or via 5 of
This the last sentence of the
Oh.
first paragraph. The undersigned unable to make the payment in the name of Srimati Hajira Begum Portuya, wife of deceased person, till further order instruction from your end.
Oh, one is Hajira and one is Hafiza.
Yes.
You are who?
Hajira.
You are Hajira.
Hajira.
And you are the first wife,
First wife.
and she is the second wife.
Second wife.
Then it has to be shared.
Yes, my lord, but the amount is payable to me as I am the eldest living widow.
Where?
My lord,
On what basis are you saying that?
there is a full bench decision of this.
No. That full bench is for family pension. We are not on that. Here, come to the circular.
My lord.
See the circular. Mr. Bulwa.
Lord.
Yes. I have asked you on the left.
That I have what I asked him for it out with that.
Yeah. Here, the payment would go to the legal heirs.
Well, I have no objection if
You have no objection if 50% is given?
as per the personal law applicable to the party.
The personal law, if she is entitled to 50%?
Yes, if she is entitled under the personal law, then I have no objection.
You see,
no problem.
the problem arises here.
Right.
If it is a case of family pension, the full bench decision will cover. But we are concerned with the compassionate family pension.
My lord.
If it's a compassionate family pension, it is he who would have, as if he is earning.
My,
Isn't it so?
my,
So would 143 rule 2 apply?
compassionate family pension is something.
You have to think about it. Okay, we'll issue
And
notice.
my lord, the other grievance is that my application for final withdrawal of provident fund was also returned on this the same ground that we have
We'll look
objected.
into it.
Fine.
First, we have to issue notice. Get hold of your, where is she? Why haven't you made her a party? Oh, you have made,
Yes.
Hafiza,
Eight.
8, we have made a party. Heard Mr. O. Loskor, the learned counsel appearing on behalf of the petitioner. Mr.
I am for 1, 4, 6 and 7, my lord.
Mr. N.J. Khatania appears on behalf of respondent number 1,
4,
4,
6 and 7, my lord.
6, and 7. Mr. S.R. Bolwa appears for respondent number 2,
And 5.
5, Yeah, 2 and 5.
Yes, my lord.
2 and 5. Mr. Principal Accountant A. Lala, Miss A. Lala, she was appearing just now. A. Lala appears for respondent number 3. State Bank, there's a standing counsel. Oh no. Okay. As the respondent numbers 1 to 7 are duly represented, issue notice making it returnable on 22nd of May 2023. As the respondent numbers 1 to 7 are duly represented by their counsels, extra copies of the writ petition be served by 12th of April 2023. As regards the respondent number 8 and 9, steps be taken by way of registered as well as usual by 12th of April 2023. You want to take her Dusty? Take Dusty, it will be faster. Ms. Bora, your matter, I didn't, although that order was there, but I'm taking up your matter. Because you did not say, you said about family pension, but you didn't say about compassionate family pension. And more particularly, you did not bring on record the 14/7/2017 document, which is the most relevant. While I was about to sign the order, I found out there is a clause 5.10,
5.10.
which is very relevant, by which you can get everything. We'll take it your matter at 2. Given number. Your item number is what? Huh?
20.
20. We'll take it up at 2. Okay. And ask your other side. Yes. So take the stick.
My lord, the registered post will be sufficient at this stage.
Very well. The case of the petitioner herein is the petitioner is the first wife of
Salim.
late Salim Ahmed Borhuya, who expired on 30 25 2022. The petitioner initially received the compassionate family pension for a period of 3 months. However, the said have been stopped on account of a petition being filed by the respondent number 8, wherein she claimed to be the second wife. On the returnable date, the learned counsel appearing on behalf of the respondent shall apprise the court as regards the entitlement of the petitioner as claimed for.
Okay, here some name may be shown in the cause list.
The respondent, the registry is directed to show the name of Mr. S.R. Borwa appearing on behalf of the director of pension.
6.
Yes, Mr. Solia.
Originally, they were master role workers
Ah.
in engineering department, and they have been after the 14 of 17 order middle of the division bench, this appeal order. They have now been getting the last pay of the first pay of the salary only without regularization. Petitioner said in their demanding pension, entitlement of pension. Petitioners went to the Supreme Court, under Article 32 of the petition of the.
Huh?
They went to the Supreme Court also,
Where?
at page 52, annexure O. Oh, annexure D, I'm sorry, page 52. Under Article 32, but Supreme Court, however, has turned back the matter. It appears that the petitioners have invoked Article 32 of the Constitution of India seeking relief of regularization in service and pensionary benefits. The petitioners claim to have served with the government of Assam. Petitioners could have very well approached the High Court of Assam.
This is regarding pensionary.
My lord,
Why did you go to the Supreme Court?
I don't know who advised them,
No, very well, rightly so. But Is it because of this particular thing?
Yes, they claim only pension, Miller. There also. Yes, that picture was not entertaining and they were giving liberty to.
These
approach
are
the
master role workers.
master role workers in engineering departments.
How many years you have served?
Since 95, prior to 95, somewhere from 94.
Mr. Borbuzari, would this be same like item 1?
Maybe. I also.
Yes, here also, my lord, maybe please to issue notice.
Same thing.
Because what I find here, my lord, they have made a statement, my lord, that they are engaged in on different dates. But precisely, my lord, under which department, in what capacity, those that environments are silent, my lord, in the writ petition. And I also do not find any appointment letter. There are only, my lord, 2 sets of documents that has been annexed here. My lord, annexer A, lordship will find from page 15 onwards.
Yes, that I have given a detailed list, my lord, of the prisoners.
These are, my lord, only the testimonials of the petitioners so far as, my lord, their service is concerned.
They are in the
From-
irrigation
from-
department, my lord.
Yes, the irrigation department is not a party respondent before this honorable court.
I made finance a party.
No. Why haven't you made the director of pension also? Pension is also important. You are asking for pension. How can this court pass an effective relief in your favor without the pension department being there? Without the irrigation department being there? As to whether you have been in continuous service, how can the finance department say?
Since they were made parties before the Honorable Supreme Court, my lord, these two were parties.
Understood, Supreme Court
In
question
page,
is different.
in page number 15, lordship will kindly come to page 15. My lord, I am troubling my lord with all this.
I've
Right.
seen it.
Yes, page number 15, kindly see, my lord. Number 1, Nurul Islam. Then
He was
the-
appointed and then terminated and
Yes,
re-engaged after
terminated
9 years.
So there is no continuous service. There is a break in service. If there is a break in service, my lord.
Here also, in
Yeah.
every case, there's a
Yeah,
break.
for all the
They were orders for re-engagement by the Honorable Court only.
When did they retire?
They are in service, my lord.
Huh?
They are in service,
They're still in service from
Service.
2003 onwards.
my lord.
from 94.
Number 9 has retired.
One
Number
retired.
8
I'm
has
sorry.
retired.
I am sorry. Number 9.
Number 9 has retired. But Mr. Sonia, the problem is that you have to bring that.
I may be allowed to make them parties.
Make
Irrigation
it,
and
because you see, not only that, you have to make the irrigation department, more particularly the office where the petitioners were working. Then only we can ask them a yes or no, whether they were in service. Unless we put them to notice, wouldn't it be difficult if you just, one party, this court would have made it. But this is not the case. Every department, there are various departments where they are working in the irrigation department, various
that is true,
offices.
that-
So everybody has to be made a party. And why are you not bringing on record those orders by which they were re-engaged? Because here initially they were for, here is a case that if you want to come within the 2003 office memorandum or 1996, there has to be a continuous period of 20 years. Now, just for example, this one. Let us see this very aspect. If you see here, page 15, Annexure A, re-engagement on 2009. 2009 till 2000 today. It's not 20 years. Second is as regards this person concerned. I think you need to bring, because another aspect of the
No,
matter
only-
here,
only
if you
one or
see,
two persons are
Huh?
having less than 20 million. Otherwise, million, all are.
Because something might be not right, because I'm telling you why. As per the Upenda's judgment, the paragraph 22 says a person who has been in continuous service for 10 years could be entitled as on 1/6/2017. Now, at page number 15, if you see annexure A, the first person out here, you say that he has been re-engaged after a long gap of 9 years or 9. Then how did he get the Upenda's benefit of 15,000?
They are payer at page 13, my lord, kindly see. They are not paying for, my lord, any minimum scale and sort, my lord.
No, they are getting. That is what I'm saying. See page 15.
Yes,
You see, the person had joined in 1994.
yes,
He
my
was
lord.
terminated in after 6 years.
Yes, they are getting.
Then 9 years, there is nothing.
Yes.
And then from 9, he had till 2017, it is not 10 years. But how did he get this fixed pay?
I do not know. These are only type copies. Therefore, my lord, his initial engagement and how they were terminated for each and every individual writ petitioner, that has to be spelled out and corroborated, my lord, by way of appropriate document. It is a court of record.
Won't you think that it would be better to refile it? Bringing all these parties out there, because you have to file an application for amendment.
Otherwise, yes.
And it also include all these, the reason why. This is, see, page 15. This very person, number 1, I don't think how it is possible. If he had joined in 1994 and he is terminated in 2000, page 15.
Yes.
Then he was re-engaged after 9 years. And as per Upenda's, the date, cutoff date is 1/6/2017. How could you have completed 10 years continuous service and got this? Isn't it Upenda says 10 years continuous service?
Yes.
Next 2 minutes.
Page 50. Paragraph 22.
Working since last more than 10 years in non-sanctioned post with effect from 1/8/2017. So I think you withdraw with the liberty to file.
I withdraw my lord.
Lord Mr. D.P. Soliha, the learned senior counsel, assisted by Ms. Emroy. Mr. R. Bapuzari appears on behalf of the respondent number
2, my lord.
2, and Mr. D. Bora appears on behalf of the respondent number 1. The learned senior counsel appearing on behalf of the petitioner submits that, taking into account the matter involved, it would be necessary to array the irrigation department as well as the respective offices in which the petitioners have been rendering service as parties to the instant proceedings. He further submit that the appointment orders he further submits that appointment orders, re-engagement orders, and as to the superannuation orders, if any, is also required to be brought on record, for which it is under such circumstances the learned senior counsel submits that he would like to withdraw the instant with petition with the liberty to refile afresh. Taking into account the submission made by the learned senior counsel, the matter stands dismissed on withdrawal. However, liberty is given to the petitioner to refile by removing those formal defects as mentioned by the senior counsel.
Okay.
Head number 7 and 8 for admission.
Yeah, but I supposed to file my affidavit. Today I am filing in item number 7. But item number 8, my lord, today I could not file, my lord.
Hmm?
Here, my lord, in 7 and 8,
SK Goswami.
both are similar, my lord, pertains to Sibsagar district regarding illegal appointment, my lord. In 7, my lord, today I am filing, my lord.
You are filing?
Yes, my lord. But 8, today I could not, my lord.
Why?
Because my lord, I have always sent it for vetting, my lord. But there is some confusion regarding, my lord, their status, my lord. That's
How many petitioners are there in item number 6? 7?
7, 3, 4, 4, I think 4, my lord.
4. And item number 8?
Here,
14.
here 14, my lord.
14.
14.
Here 14.
Item number 14.
Yes.
What is your
Here 3 in
difficulty?
item number 7, 8, my lord. 3 petitioners, my lord.
There? Why haven't you filed it?
No, because, my lord, there is one more other petitioner with similar name. That is Unananda Soikia. That's why some companies has name, my lord. So, my lord, I'll file tomorrow or day after tomorrow, my lord.
All the affidavits will be filed
Yes, yes, my lord.
by 12.
Yes, my lord.
You're sure?
Yeah.
Without fail?
Yes, my lord.
We'll have it after vacation.
Yes, my lord.
Fourteen petitioners in 6435. Huh?
Yes, my lord.
7, 10, and 14 have received appointment letters
Yes, yes, my lord.
and have been newly accommodated.
Yes.
You have taken instructions out there. They are happy with that.
They have taken everything.
Huh? They are happy with that.
Not happy,
Huh?
not happy, but in compulsion. my lord.
No, they have
Because,
taken it.
They have not getting salary for several years, so they have no other option but to
They have
accept.
accepted it.
In compulsion. They have accepted.
Did you accept that same as without demur? Hello. Heard Mr. Your name?
H.C. Sharma.
H.C. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatunia, the learned standing counsel for the Elementary Education Department. This court, Mr. N.J. Khatunia submits that in WPC number 6435/2017, you are filing today?
Yes, my lord.
He is filing the affidavit in opposition today. And in WPC number 2516/2018, the Elementary Education Department would be filing the affidavit by 12th of April 2023 without fail. Taking into account the same, let this matter be listed again on 3rd of May 2023.
Obliged, lord.
The respondent, the petitioner shall be at liberty to file their reply, if any.
Obliged.
9.
Yes, Mr. Dasgupta.
Lord, in this particular the earlier occasion, Lord,
Oh, they don't want to file their reply.
they do not
well.
want to file a reply.
They will argue. Oh, you. Is that the case?
Yes,
Very bad case.
yes. Yeah, yes, Lord.
Huh?
I shall try my best.
Tell me.
So let us, without going through the facts, let me start the argument on law point. Lord.
Yes,
Then thereafter, Lord, I shall come to the facts. No, Lord, put a question. Lord, I would like to refer this book, Lord. That is the Indian Constitution cornerstone of the nation. Garwell, Austin, Lord.
Yes.
No, Lord, basically, my Lord, I would like to refer first preamble of the Constitution. Now, my Lord, so for the preamble is concerned, it states that we the people of India having solemnly resolved to constitute India as a sovereign democratic republic to secure three things, three precepts. One is justice, liberty, and equality. Now, let's look at justice is concerned, social, economic, and political. These three things are required. Number this way, I would now will refer to Article 38.
A constitution kon diyo. Yes.
Now, first, Lord, so far preamble is concerned,
Yes.
with the people of India having sovereignty to secure all of its citizens. Number one, three precepts are there: justice, liberty, and equality. Now, so far justice is concerned, social, economic, and political. Now, Lord, if we go through the provisions of Article 38, all these things are included in the Article 38 of the Directive Principles of State Policy. Let us go through Article 38 of the Directive Principles of the State Policy.
Yes, 38.
38. The state shall strive to promote welfare of the people by securing and promoting its promoting as effectively as it may social order in which justice, social, economic, and political shall inform. The contents of first precepts are at the very beginning of the article. Now, in order to secure these things below, some other articles were incorporated. So I will particularly I will refer to this book below. Now, Lord, this is the first thing, Lord. So far, subclause 2 is concerned, it is not very pertinent. It was subsequently amended in the year through 44 amendment. Now, Lord, come to Article 39, clause A, B. The state shall, in particular, direct its policy towards securing, number A, the citizens, men and women, equally have the right to an adequate means of livelihood. Then clause B, the ownership and control of the material resources of the community are so distributed as best to subserve the common good. Now, your lordship may come to Article 41. Right to work, to education and public assistance in certain cases. The state shall, within the limit of its economic capacity and development, make effective provision for securing the right to work, to education and public assistance in cases of unemployment, old age, sickness, disablement, and other cases of undeserved work. Now you will also come to Article 37. The provision contained in this part shall not be enforceable by any court. Unenforceable. The principles are not enforceable. But the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply this principle in making laws, and it shall be the duty of the to apply this principle in making law. Now, Millard, I will refer that book. Millard. I'm referring this book because of fact. Millard, this book was, some paragraphs of this book was referred in 3 landmark cases: Keshavananda Bharati, Minerva Mills, and that is Unni Krishnan. Now, your lordship, come to page 63. Let it go.
But Mr. Radgupta, tell me one thing. If the directive principles are not enforced, yes, there is a duty. But if it is not enforceable, can this court issue a mandate?
Millard, so far directive principles and fundamental rights are concerned, there is no enemy. One is supplementary to other, and one is complementary to other. If there is my endeavor before your lordship, I know I have my if there is any some act which provides pension, then this act should be read an act under Article 45 of the directive principle. And in order to constitute that act, Millard, we can take the recourse of the contents of the directive principle. In order to fortify that thing, Millard, I would like to refer to 2 judgments.
But
Millard,
isn't the
petitioner
pension
throughout her life?
Yes, one thing is there. A pension, concept of a pension or anything for all work, hard work being given out there for which there's something being given is a necessity which would be a policy of the government. But can this court interfere with that by exercising judicial review?
In certain, my case is an exceptional case, Millard, that I would like to place. Only 2 or 3 points that I would like.
Because the
My
law,
case before your lordship is that.
because the law otherwise is clear. The pension though not at the bounty, which will be at the sweet will of the employer. No, none.
No.
But the entitlement of the pension is based upon a statute. In the instant case, the rules of 1969 or whatever.
1969 is our case.
In our case. Unless and until those rules are there, and you come within the ambit of those rules, can this court direct?
If the court
In a
cannot
case of
direct, the court can direct the respondent to consider her case because of this truly fact and situation. In the light of the judgment that I would like to refer to.
What is the peculiar fact of the case?
Peculiar fact is that, Lord, she was appointed as an honorary teacher. Unfortunately, when she was appointed in the honorary teacher in that school was a provincial.
It was a provincial school.
At that point of time. But throughout the life, she worked in that school. And the school inspections was carried out. And in all inspection, her name was recorded. Now, my lord, after her appointment, one lady was appointed and she approached before this honorable court. And this honorable court passed an order to consider her case. At that point of time, that rule was there as a person concerned who worked for a period of 10 years service, her service shall be regularized. And this court passed an order to that effect that her case should be regularized. And her case was regularized. Now she again approached before after completion of 20 years of service, she approached before this honorable court for an order. This honorable court passed an order to the effect that the education department or the concerned department should consider her case. When her case was not considered, she approached before this court by filing a contempt petition. In that contempt petition, the government took a plea that she was appointed in a provincialized school, so her service cannot be regularized. She preferred a writ appeal before this honorable court, and this writ appeal was disposed of with some observation that when and if the government takes more resort to a recruitment process, then her case may be considered. By the elapse of time, since 1975 to 2012, she attained her age of superannuation. It is not the case that she had not worked. That is her case. I have annexed all those.
But whatever may be, Mr. Dasgupta, it's sad that the petitioner didn't get it. But if the statute does not give the authority, how can this court give it? Would this court then not be standing in the shoes of the executive?
This court is also a state under Article 12.
Who?
This court. The court itself.
The court cannot be a state. The court is not a state. The administrative office of the High Court would be a state, not the court. You can't file a writ against me.
So, that is not the court has some
The
duty.
administrative authority would be no. This court cannot be a state within the meaning. The office of the Chief Justice would be.
That is the administrative side. Court is a state, undoubtedly.
But not the High Court.
But I have, though I have not got all those decisions, but I have come across some judgment wherein it states that yes, court is also obligated to consider the principles of natural justice.
Because you see, a court cannot create a right. The law is very settled. A court cannot create a right. A court can only determine and if necessary to enforce. That is the power of the court. If it does more than that, like in various PILs, what the court is doing, in many Supreme Court, they are doing. They are saying that in bringing it within the ambit of Article 14, 19, 21 and all these things and says that this particular right is already there and therefore he is entitled to
court.
It doesn't create a right.
What you are trying to say, the court can declare some rights of a citizen or right of a person.
No, a court can declare a right provided there is a right which exists.
For a citizen or a person.
But the court cannot create a right on behalf of somebody. Because if the court creates a right, then there is nothing out there. All judgments out there, there will be promissory estoppel will apply.
Then, Millard, I would like to refer this unification judgment.
Huh?
That judgment, Millard.
Yes.
Yeah. That judgment. Should I refer that judgment?
Which one?
1996. 645.
Yes, which one? Minerva?
No, this is Unnikrishnan.
Yes.
then Miller, I shall refer this book later
Mhm.
because this book has some reference to legality. Now, from paragraph 153 to 165.
Yeah.
Here, Miller, the brief descriptive history of directive principle
Hmm.
have been part.
Hmm.
Paragraph 153. Not it. Oh.
Yeah.
Oh. Look, this judgment, you're
Yes, yes, I'm reading. Paragraph 153 to 155.
Oh, you're having. I can.
Yes, I have it.
Oh, not. Interplay of part 3 and part 4. Part 3 is direct fundamental right, and part 4 is directive principle. This court has also been consistently adopting the approach that the fundamental rights and directive principles are supplementary and complementary to each other, and that the provisions in part 3 should be interpreted having regard to preamble and the directive principle of the state policy. The initial hesitation, that is what your Lord just now Lord asked me, the initial hesitation to recognize the profound significance of part 4 has been given up long ago. We may explain. While moving for consideration the interim report on fundamental rights, Sardar Vallabhbhai Patel described both the rights mentioned in part 3 and part 4 as fundamental rights. One justiciable and other non-justiciable. In his supplemental report, he stated there were two parts of the report. One contains fundamental rights which were justiciable, and the other part of the report refers to fundamental rights which were not justiciable but were directives. These statements indicate the significance attached to directive principles by founding fathers. It is true that in the state of Madras versus Champakapuram, such and such, fundamental rights were held to preeminent vis-a-vis directive principle. But since then, there has been a perceptible shift in the court's approach to interplay of fundamental rights and directive principles. As per back in 1958, it will probably a lot of rise.
We'll do one thing.
Hold on,
We'll
yeah.
hear it some other day
Hold on, just hold on.
because it's nearing vacation. But the problem, only one thing which is there. I just read the entire thing from 153 to 167. I've read it. Now, if you see those things, I could understand out there is just like the preface, the preamble, the directive principles play a role in interpreting the fundamental rights.
Yeah.
It does.
Yes.
That
Yes,
is what
that is
has been
correct.
stated, that the directive principles, like just for example, a right to education, giving them education is one of the directive principles at one point of time prior to
At
negotiation.
point of time, subsequently, it has become a
It has
fundamental
now
right
been brought under 21A. But at that point of time, while interpreting the directive principle for providing education, the court read within the limit rights under right to life, the right to quality education also.
Yes. Yes, yes.
By in bringing in or having a on account of the complementary nature of
Yes.
the directive principles with the fundamental
Yes.
right, and also further bringing in the interplay between both these rights.
Yes, yes. Correct.
One is
correct,
the
correct.
right, one is the
Absolutely
duty.
correct.
That
Yes.
I understand.
So to enlarge the scope of the fundamental right, the content of directive principle may taken into account.
But the problem arises in your case is that when the law, there is a particular law prescribed,
Yes.
the statute,
Yes.
which prescribes a particular mode in which a person would be entitled to pension.
Yes.
Means he has to be in the government service, permanent and substantive, and he has to be paid out of the funds of the government. If the statute says a thing to be done in a particular manner, it has to
Must
be done.
in that manner.
Unless that statute is held to be in violation to Article 14.
Yes, yes. 100%.
By interplaying it with 39 and 37.
Yes.
But that is not the case here.
Yeah, yeah. That is what I would like
We'll hear it after vacation, Mr. Das.
Oh, that is of course true. The one thing that I would like to just
Yes.
point out for our thinking, when a statute, so there are different statutes. One is the Minimum Wages Act. It is a statute under the directive principle. When a statute relating to pension, it is a statute under the directive principle. So if there is any provisions which requires some interpretation of that very particular statute, then the contents of the directive principle may be taken into account. That is the mandate of Bandhua Mukti Morcha, 1984. That I would like to place before your lordship. Any date, your lordship.
We'll have it after vacation. When do you want it?
Any date, your lordship. I have to work hard.
We'll have it on 20. 20?
20.
April?
Well, you'll also fix it, change it, let it be 20.
But Mr. Ida Gupta, the senior counsel, assisted by so-and-so. And Mr. P. Chaudhary appears on behalf of
PTC. Okay.
PTC. Mr. N.J. Katani appears on behalf of
Elementary education.
Elementary Education, and Mr. A. Hassan appears for the Accountant General.
Well, I will pass it to your lordship.
Which
So
one?
for these books.
Oh, no, you take this book. I don't.
No. I have got the photo structure of the relevant photos. If required, I can give it to you.
Let the matter be taken up for further consideration on 24/2020. Matter of 2019, you
Yes,
are
my lord.
still.
This is also regarding one of the same illegal appointment of Sipsagod district. He may also be accommodated as my lord teacher, my lord.
Yes, but you have.
Yeah, as per instruction, Your Honor, we have received the general insurance and the gratuity so far.
We have received your GPF.
General insurance and gratuity, the leave encashment, salary have not been received.
Damn it. Not idiot.
Yes, my lord.
They are yet to file
Then
the
you
affidavit.
don't know the pattern.
Maybe my lord, but it seems to be similar, my lord. That's why it's better to open instruction, my lord.
Area salary from March 2012 to January 2018.
Yes, Lord.
You have received your
General insurance and the gratuity,
general GIS
GIS, and gratuity.
and gratuity you have received. but no pension.
no pension, no retirement benefits.
But Mr.
G. Regma.
G. Rengma, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatoni appears on behalf of the Elementary
Elementary.
Education Department. The learned counsel for the petitioner had submitted that he has received the GIS as well as the gratuity. However, the petitioner has not received any other pensionary benefits, including the arrears for the period from March 2012 to January 2018. Mr. N.J. Khatuni and the learned counsel appearing on behalf of the Elementary Education Department seeks for an accommodation. Taking into account that the matter is pending since 2019, this court gives the final opportunity to the Elementary Education Department to apprise this court as regards the entitlement of the petitioner. This the matter again on 3rd of May 2023. Liberty is given to the petitioner to mention the matter for upgrade.
Obliged, Lordship.
12,
Mayor.
Yes.
Letter, my lord, some increments and my lord, efficiency bar regarding the in the for the year 2002 to 3, my lord, was not passed, my lord, and
Lordship, I need some time to file my affidavit.
My lord. My lord, in the meantime, petitioner retired, my lord, and he has got only the leave encashment and GIS, and no other benefits were. Even the provisional pension was also not given.
It is not a Lordship pleaded case of the
When did the petitioner retire?
My lord, April 2022, my lord.
So those prayers are not
Not
here,
there.
what you are asking for.
Lord,
No, my lord.
This is a case pertaining to you are asking for certain financial upgradation.
Yes, my lord.
So that aspect is different from that aspect.
Yes.
So how can I bring in that aspect?
My lord, if this, my lord, increments are not allowed, my lord, then pensionary benefits also not will not be cleared, my lord. So, my lord, first this
You bring it by way of an additional affidavit, these aspects. Okay, let's look into it. Heard, Mr.
K within.
K. Uddin, the learned counsel for the petitioner. Mr. N. Upadhyay appears on behalf of the Irrigation Department. Mr. N. Upadhyay seeks for an accommodation to file their reply. Taking into account that the matter pertains to the year 2021 and the notice was issued as far back as 8/10/2021. This court grants the Irrigation Department a final opportunity to file their reply by 10th of May 2023. List the matter again on 17th of May 2023. The petitioner is given the liberty to file an additional affidavit bringing on record the fact that the petitioner had retired in the meantime during the pendency of the writ petition.
obliged.
14,
Matter pertains to my lord non-payment of pension matter.
Pension of-
Retired on my lord 2014.
You have not got your pension?
Yes, no.
Nothing?
Stipendary teacher, your Lordship. That's the probably the reason why.
Oh, yes, yes. Stipendary teacher.
Your Lordship is, if your Lordship comes to page 20, that is the date of receipt of time scale of pay, your Lordship,
Page 20.
20. The following incumbents I have allowed to do time scale of pay plus other allowances as admissible under rules with effect from the date shown against their names as they pass the junior basic training examination regularly without break against the selection. The post were originally created by cost of an person. Date of this is the date 21st January 2000.
This is because of that.
Yes, my lord.
Now my judgment, how does it impact it? Will be entitled to the old pension scheme. We will dispose it of, directing that the petitioner
Yes,
would be
ma'am.
entitled as per and
Yes.
to do the needful within a period of 4 months.
Yes, my lord. Yeah, my lord, the only confusion because of my lord, in case of petition, my lord, NPS account has also been opened and GPF account.
Understood. If the NPS account has been opened, then whatever amount the government has given, that has to be deducted. Isn't it so?
Yes, ma'am.
Heard Mr. S. Kotaku, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatonia appears on behalf of the respondent number 1,
4,
4, 5. Mr. S. R. Purva appears for the respondent number 1, 2, and 3. And Ms. appears for the respondent number 6. Sorry, Mr. Borpuja, your name is not there. The case of the petitioner herein is that the petitioner was appointed on 27/1/1996 as a stipendiary teacher against the retired vacancy of one Okon Neok of Barampur LP School and posted at Meramuk LP School. Subsequent thereto, the petitioner passed the junior basic training examination on 21/1/2006 and thereupon was allowed to draw the regular scale of pay with effect from 5/10/2005. The petitioner retired. When did you retire?
Lordship, in year 28
The
to
petitioner
2014.
retired on 28/2/2014 while working as the assistant teacher in Somaguri LP School. However, pursuant to his retirement, the petitioner have not received his pension as well as his pensionary benefits, for which the instant writ petition has been filed. This court, by an order dated 17/11/2021, had issued notice making it returnable by 6 weeks. In terms with the said order, and this court further, by the said order, also directed for payment of provisional pension to the petitioner. No affidavit has been filed by the respondent authorities till date. However, Mr. N.J. Khatonia, the learned counsel appearing on behalf of the Elementary Education Department, have placed on record a communication issued by the Additional Director Elementary Education to the Secretary to the Government of Assam Elementary Education Department, wherein it has been mentioned that on account of the petitioner getting his regular scale of pay after 1/2/2005, the petitioner have been included within the ambit of the new defined contributory pension scheme 2009, for which the petition 2009. However, as the question as to whether the petitioner would be entitled to under the Assam Service Bracket Pension Rules 1969 or the new defined contributory pension scheme 2009 was yet to be ascertained, the pension as well as the pensionary benefits of the petitioner could not be finalized. Mr. S. Portagu, the learned counsel appearing on behalf of the petitioner, have drawn the attention of this court to the judgment rendered in the case of Purnima Hor, WPC number so and so, dated, judgment and order dated
31/3/2020.
31/3/2023, passed in Purnima Hor versus State of Assam in WPC number so and so, and other writ petition, wherein this court, after taking into consideration the provisions of the Assam Elementary Education, what is that name? Provision of Assam Elementary Education Provincialization Act 1974, comma, Rule 3 and 4 of the Assam Elementary Education Provincialization Rules 1977, as well as the provisions of the Assam Elementary Education Provincialization brackets provincialization is bracket Service and Conduct Rules 1981, had observed that those stipendiary teachers who were appointed prior to 1/2/2005 by the Deputy Inspector of Schools, irrespective of when they have received the regular scale of pay, would be entitled to the pension in terms with the Assam Service Pension Rules 1969. In the said judgment, this court had further held that the stipendiary teachers appointed prior to 1/2/2005 would be entitled to the benefit under the Assam Service Pension Rules 1969, and they are not covered under the new defined contributory pension scheme 2009. It was also observed that those stipendiary teachers would also be entitled to subscribe to the GPF and would also be entitled to all other pensionary benefits to which a government servant of corresponding rank is entitled to. Taking into account the said aspect of the matter, this court therefore disposes of the instant writ petition holding by disposes of the by declaring that the petitioner herein would be entitled to pension in terms with The Assam Service Pension Rules 1969 and would also be entitled to subscribe to the GPF in terms with the General Provident Fund bracket Assam Service Rules 1937. The petitioner further would be also entitled to all other pensionary benefits to which a government servant of corresponding rank would be entitled to. In view of the said declaration, this court further directs the respondent authorities, more particularly the Director of Elementary Education, to take appropriate steps. The Director of Elementary Education as well as the Director of Pension to take appropriate steps to grant the petitioner the pension as well as the pensionary benefits in terms with the above declaration, which shall be done within a period of 4 months from the date a certified copy of the instant order is served upon the Director of Elementary Education as well as the Director of Pension. Before parting, this court would further like to observe that in the meantime, an NPS account has been opened whereby there has been certain contributions being made on behalf of the state as per the provisions of the new defined contributory pension scheme 2009. The said amount shall be deducted while computing the pension of the petitioner. With the above, the instant petition stands disposed. The instructions so produced by Mr. N.J. Khatonian is kept on record and marked with the letter X.
Yep.
Mr. Bhottakur, all other people should thank you because of that particular 1/2/2021. Everybody have got the death come retirement, although they didn't have the prayers.
16.
Yes, Mr. Patki.
My lord. So regarding non-payment of my lord pensionary benefit, my lord, only because of my lord stating that my lord the qualifying service has not been reached, my lord.
Non-payment of pensionary benefits.
My lord, stipendary teacher, my lord.
Huh?
He is a stipendary teacher, my lord, and appointed in the year 1999. And thereafter, my lord, after passing the basic training, my lord, he received the regular pay scale, my lord, in the year 2002, my lord. And subsequently in the year 2010, my lord, he retired. And now, my lord, refused to sanction pension only because that the qualifying service counted from the date of receiving the regular scale of pay, not from the initial date of
You are a stipendary teacher.
my lord.
Lordship, we have Director of Pensioners, we have filed our affidavit, Lordship. So his
I
net
also filed
qualifying
reply.
service only 7 years, 7 months, 19 days only.
Huh?
He has not completed 10 years of qualifying service, Lordship.
Why?
Lordship may kindly come to para 7 of our affidavit. Filed by respondent number 5, Lordship.
There are 7 of your affidavit. Where is your affidavit? It is not there. The affidavit is filed by respondent number 5. Where is it? So, to mark work authority. Important number, reply. Yes, got it. Yes, tell me. On 799, he was appointed as stipendary.
Lordship.
Then
Then regular time scale with effect from 12/8/2022
two. Then
and retired on 31/5/2010.
okay. Then
So net qualifying service comes to 7
why
years.
you are taking into account this regular time scale of pay? Why?
But Lordship, perhaps this recent judgment it will cover.
No, no, no. Have you seen that they recon service condition? You have it?
This one I
Give it to him. Kindly come to page 310.
Lordship.
Okay.
Lordship.
And you see period of service. 2-4.
Period of service.
Ah.
Period of service means the period of continuous service against the sanctioned post.
So if he was appointed against a sanctioned post, his period of service has to be taken there.
Lordship.
Then how are you taking into account this regular time scale of pay? Tell me. Then you see this pension 6, page 314.
Pension and gratuity, etc.
Shall be entitled to pension as admissible to the government employees. The service teachers who opt for pension schemes will discontinue the dividend in year, because earlier to that the 68 was there,
Lordship.
which was under the board. Those employees were under the board, so they were taken. If we go under the 68 Act, so if those were under the board, then they were doing under the CPF. Yeah, contribution and open account and deposit the so and so contribution along with the open so and so. So the period shall be counted from the date when we were called to receive the benefit of heir during the board's reserve. So the period has to be taken against from the date on him from his
Initial
appointment. Then how are you taking on the basis of this? That is your entire case.
My lord.
We dispose it of.
Lordship.
Heard Mr. K.R. Padgiri, the learned counsel, appearing on behalf of the petitioner. Oh, nothing has happened all this while. Your matter was, I issued notice on 24/2022, and the matter has come today only. Mr. Borpuzari, tell me one thing. Why nobody argued on this service code conduct rules at the time of stipendary teacher? Nobody argued on this service code. Nobody argued on this 81 rule. Is I who was looked it and have given it to them. But nobody argued this. And I thought whether this rule is not no longer there, maybe the lawyers may be knowing better. Then I searched it up. No, it is still there. Then why nobody, not a single person, you were there, argued on the 81 rules. And the 81 rules was the catch.
Yeah.
If you see this, see the appointment. how the appointment happens, everything is given there. Terms on the services of all teachers of elementary taken on so and so as provided under so and so shall be amended, service rendered under repeat act. It is being given very clearly. And not only that, most interesting is section 4B. I didn't want to say more in my judgment because 4B is one of the most dangerous things. Person concerned, if you don't have anything adverse, is deemed to be confirmed. And you have whether you send him to training or not. And a person who is otherwise 45 years, who is in service, he has to be given after 3. 4B. He has successfully undergone necessary training as may be prescribed to answer, provided that these teachers who have completed 45 years of age or have completed 3 years of continuous service after provincialization, but no facilities have been provided to him or her for prescribed training, will be confirmed, provided there is nothing adverse against him. So by dint of this provision, the proviso, he gets confirmed.
Right, my lord, flowing from that.
Absolutely. So I didn't understand why none of the council were appearing on this side.
My predicament is that, my lord, I present, so I go by the consent that, my lord.
No, definitely not for you. But the petitioner's counsel should have argued this.
That will have-
Somebody was making an argument for the purpose that they were in the status of a probationer. They were those status. But why this 4B, the proviso to 4B makes it clear that they have to be confirmed unless you say that there is adverse.
Then there is no room for further deliberation, no debate.
And that is the reason why a training is therefore necessary, not necessary also, if that is. And this, you see, further see here, how does the training come into? You see, in rule 3 of the 77 rules does not say specifically. Prior to 2005, it does not say specifically. Then here it says, as per rule 3, the teachers on appointment, so the appointment has happened, should be required to undergo junior, basic or normal training course or any other recognized by the government. This is the mandate on which the training happens.
So therefore, in all the appointment letters, my lord, there is a clause that you have to undergo.
That is the reason why it happens. Because the 77 rules, if you see that earlier one which I quoted in my judgment prior to 2005, it says that may have to go for a training. It is not may. But this mandates the training has to be.
There other exclusion clauses are also there on the happening of that event if he attends for 5 years.
Yes.
The right flow.
Right flows from there.
No, that would have saved much of the time.
Huh?
That would have
Yeah,
saved
if
much-
this was shown, there was no problem at all. This was the catch.
the statute itself is giving that.
Huh? I don't want to make the petitioner councils more clever, but there are something more they could have done. Yes.
How I my lord.
Heard Mr. K.R. Patri, the learned counsel for the petitioner. Mr. S.R. Borua appears on behalf of the Director of Pension. Mr. N.J. Katonia appears on the behalf of the Elementary Education Department. Mr. R. Borpujari appears for the Finance Department. The case of the petitioner hearing is that the petitioner was initially appointed as a stipendiary teacher on 7/12/1999. The said appointment was made against the post created by the DE Assam memo number EPG.567 91/105 dated 16/11/1991. Thereupon, the petitioner passed his junior basic training on 12/8/2002, and he received the regular scale of pay thereafter. The petitioner retired from service on when?
31st May 2010.
31st of May 2010. The petitioner, as per the petitioner have completed more than 10 years, 5 months, 24 days of qualifying service, for which the petitioner would be entitled to the pension as well as other pensionary benefits. The petitioner, being deprived of his pension and pensionary benefits, have instituted the instant writ petition. This court, by an order dated 24/2022, had issued notice making it returnable by 4 weeks. It appears on record that the respondent number 5, that is
Director of Pension.
the Director of Finance,
Pension, my lord.
a Director of Pension, have filed an affidavit in opposition on 25th of August 2022. In paragraph number 7 of the said affidavit in opposition, the fact that the petitioner was appointed as a stipendiary teacher on 7/12/1999 is admitted. The fact that the petitioner was allowed to draw the regular scale of pay with effect from 12/8/2002, and that the petitioner retired from service after attaining the age of superannuation on 31/5/2010 is also admitted. However, the stand of the Director of Pension is that as on 31/5/2010, the petitioner only had qualifying service of 7 years, 7 months, 19 days. And as such, in terms with the provision of Rule 108 and 110 of the Assam Service Bracket Pension Rules 1969, the petitioner is only entitled to service gratuity amounting to rupees 47,742, which was paid to the petitioner. The issue, therefore, arises in the instant case as to whether the petitioner's qualifying service was 10 years, 5 months, 24 days, or was it 7 years, 7 months, 19 days? The issue can be looked into. This court is of the opinion that the issue can be adjudicated on a bare perusal of Rule 2 Roman 4 of the Assam Elementary Education Bracket Provincialization Bracket Closed Service and Conduct Rules 1981, which defines the period of service to mean the period of continuous service against the sanctioned post. In the instant case, it would be seen that the petitioner was appointed on 7/12/1999 by the Deputy Inspector of Schools.
Yes.
Against the sanction post by DE Assam memo number EPG.567/91/105 dated 16/11/1991. Therefore, the period of service of the petitioner has to be counted from 7/12/1999. Consequently, if the period of service of the petitioner is counted from 7/12/1999 till the date of retirement on 31/5/2010, the total service, qualifying service of the petitioner would be 10 years, 5 months, 24 days. Next, a perusal of Rule 108 of the Assam Service Pension Rules 1969 would show 108B. That the officer would be entitled to pension after rendering a service of not less than 10 years. In that view of the matter, the instant petition therefore stands disposed of, with a direction to the respondent authorities to decide the entitlement of the pension of the petitioner by taking into account that the petitioner's qualifying service is 10 years, 5 months, 24 days. And thereupon grant such benefits to which the petitioner is entitled to under the Assam Service Pension Rules 1969, as well as other pensionary benefits to which a government servant of corresponding rank would be entitled to. Next, the said should be done within a period of 4 months from the date a certified copy of the instant order is served upon the Director of Elementary. You have done the problem only. You can do it now. Do they have to send a proposal? No, no. You have to do it.
Yes.
Within 4 months from the date a certified copy is served upon the Director of Pension. Before parting with the record, this court also further makes it clear that while recomputing and refixing the pension and fixing the pension of the petitioner, the amount so paid to the petitioner on account of gratuity of rupees 47,742 shall be duly deducted. With the above the instant petition.
Obliged. Obliged.
23 to 25.
Yes, Mr. Sharma.
Lordship, in this matter, in one of the writ petition 1015, we have filed our affidavit, Lordship, where the basic issue has been already been narrated.
Very well.
This is regarding, Lordship, obtaining of a fake certificate by the petitioner, whereby the date of birth has been wrongly written as 1965, whereas as per the admit card of the SEVA, it ought to have been 1958. Therefore, we have already written a letter to the SEVA as well as the State Madrasa Board to authenticate the date of birth of the certificate. And subsequently, that response from the SEVA and the State Madrasa Board is still awaited, Lordship. So, subsequently, the writ petition, another writ petition has been filed, 6562. We will be going to file our affidavit in this. And we are awaiting, we have already sent the reminders also to the State Madrasa Board as well as the SEVA. So we are awaiting that advice from the department. So further 2 weeks time may be granted to file our affidavit in 6562. Otherwise, the basic fact has already been narrated in our affidavit in 1015, Lordship.
You have filed a affidavit.
In 101, one of the writ petitions.
You have filed reply.
Reply.
You have filed.
In the second, other two cases, they have not come up with their affidavit.
We require to file our affidavit in 6562, Lordship. Now there are 3 writ petitions. In 1015,
What is
we have already-
5529?
Lordship.
What is 5529?
What has happened, Your Lordship, in 1005, Your Lordship, when our salary has been stopped, Your Lordship,
Our?
my salary has been stopped.
Our or my?
My.
My. Okay.
Single.
My salary has been stopped, Your Lordship. When my salary has been stopped, Your Lordship, I came before this honorable court by filing the writ petition. When we filed the writ petition, they came up with their affidavit, Your Lordship. In affidavit, they said that there is an inquiry conducted by the additional deputy commissioner, Your Lordship, and there is a report against me where it has been stated that the certificate I have obtained and the date of birth that I have put is not correct. So we put that report to challenge in the second case. And by the time, Your Lordship, that case is they filed affidavit and further order has been passed by the director, Your Lordship, asking the authorities to lodge FIR against me and also to recover from me, Your Lordship, the excess payment.
You retired?
No, I have not retired, Your Lordship. But Your Lordship, only thing, Your Lordship, in all these proceedings, my case is that I have not been hurt. What they have. And I have materials to show, Your Lordship, what they have. The ADC has, Your Lordship, found in his
Mr. Bhattakur, have you gone into the media one judgment?
latest judgment.
Huh? Good for it.
Lord.
It will help you a great deal.
Lord.
Because the principle of natural justice has been more exponentially explained.
Lord.
Anyways, we'll give him another time.
Lord.
When?
That's a 2 weeks time, Lord.
2 weeks, okay. We'll have it on 10th of May.
Lordship.
Lord.
At the request of Mr. S. Bhattakur, the learned counsel, I already put it. Heard Mr. S. Bhattakur, the learned counsel, appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the Elementary Education Department. Mr. P.N. Sharma submits that they have already filed an affidavit in WPC number 1015/2021. And to the said affidavit in opposition, the petitioner have also filed an affidavit in reply. The Elementary Education Department is also taking steps for filing reply in WPC number 6562/2022.
Lord.
If this will suffice for 5529.
Lordship.
This will suffice for 5.
He further submits that the affidavit to be filed in WPC number 6562/2022 would suffice for the in respect to WPC number 5529/2022 also. And the learned counsel further seek an accommodation of 2 weeks in that regard. Let the matter be listed on 10th of May 2023. The petitioner, the Elementary Education Department shall file their affidavit by 3rd of May 2023. And the petitioner, if so advised, would be at liberty to file their reply by on or before the next date.
Obliged.
I will be given liberty to mention the matter, Your Lordship,
Huh?
for upgradation on the next date. Your
Liberty is given to the petitioner to mention the matter for upgrading.
Lordship. Thank you, Your Lordship.
You have no protection?
No, Your Honor.
26.
May I please, Lordship?
Yes.
One instruction is received, Lordship, that it is not enough, Lord. Some more time will be required, Lordship.
What is the matter about?
Lordship, this is regarding payment of leave encashment in GIS, your lordship. GIS and leave salary. They have filed an affidavit against it, we have filed a reply, my lord.
You have retired?
I retired, I'm getting my pension.
Ah.
They have filed one affidavit stating that no leave encashment is due to me. Against it, we have filed a reply, relying on a communication issued by them, your lordship.
Why no leave encashment?
Lordship, let us receive the instruction, Lordship. More time will be required, Lordship.
No, there has to be a justification why he is not entitled to leave encashment.
Lord.
What is the justification? No,
Receive any instruction, Lordship, regarding this.
The last occasion, they were directed to obtain instruction.
only remaining is leave encashment.
GIS.
GIS also. GIS, why not? Why he is GIS? I think a person is subscribed to the GIS.
Yes, ma'am.
Then why is not being paid? Have you got the GIS?
No,
You want what? Leave encashment and GIS.
GIS.
Nothing more.
And leave salary also.
Leave salary also.
Amounts to lordship,
Leave
whatever is
salary and
due-
leave encashment are
I
not the
think it
same.
would be the same. It would be the same.
Then
Lord, that may be given, Lordship. I will obtain that.
only that two. Heard Mr. P. We are the learned senior counsel assisted by, yes, who is assisting?
P. Boraman.
P. Bora. Advocate for the petitioner, Mr. A. Chakraborty appears on behalf of the food, civil supplies and consumer affairs department. The senior counsel appearing on behalf of the petitioner submits that the pension as well as the other benefits have been received by the petitioner, save and except the leave encashment and the GIS amount. The learned counsel for the Food, Civil Supplies and Consumer Affairs Department shall apprise this court on the next date as to why the said entitlement have not been, why the petitioner have been deprived of the said entitlement delay. Is the matter again on when?
First May, Lord.
1st May.
Second week of May, Lord. Second week of May.
On 8th of May.
Right.
The instructions were produced by Mr. A. Chakraborty. During the course of hearing, it's kept on record and marked with the letter X.
May I get a copy?
I
What?
will provide. I will provide.
Nothing is there.
Bless.
27.
May it please your lordship, I am paying for respondent number 1, 3, and 5, my lord.
Hmm.
I have received instruction, my lord. I need 2 weeks time
For what?
for filing my affidavit, my lord.
What is his case? What is his case?
His case, my lord, for his-
Overstay.
No, my lord.
What is your case?
Yes, my lord,
No,
the
my lord.
father of the petitioner starting as a master worker, my lord,
Ah,
and thereafter he retired on, my lord, 28 to 2008, my lord.
8.
8, my lord.
Then
Then, my lord, the respondent has not paid the, my lord, pensioner revenue only because of, my lord, not completion of 20 years. After deduction of 6 years.
oh, Sanjita Roy.
Sanjita.
But my lord, his petitioner is 52 years age, my lord. And my lord, at that time when his father was superannuated, my lord, that office notice was not come, my lord.
Huh?
So I need to file my affidavit, my lord.
Understood, but petitioner is 52 years.
Yes, my
Who
lord.
is petitioner?
Son, my
He's
lord.
a son.
Son,
Yes,
my
my lord.
Okay.
lord. Speaking, my lord, arrear pension, my lord.
Who are you to get the pension? You are only for area pension.
Area.
For which period? 2008
Till
to
the death of my mother. Up to
mother.
mother.
But
Mother,
tell me one thing,
Father
Mr.
died when
Padgiri, one thing, tell me, why your eyes have opened so late? Where will they keep records? Nothing was done by your father. Nothing was done by your mother. Why this you are taking up this issue now?
But Sanjita Roy passed in the year 2018. Madam.
Hmm?
Sanjita Roy passed, my lord, order passed in the year 2018. Madam.
So,
And my
why
lord,
didn't you be a part of Sanjita Roy?
Because my lord, that deduction of 6 years, my lord.
So you should have challenged it then. You could have challenged prior to that also. Was Sanjita Roy disposed of on the day on which it was filed? No.
No, madam.
It has been, this is a matter of 2014, if I'm not wrong. Because this came after that office memorandum of 2014. Then, why you have woken up so late?
Father died, my lord, 23 to 2020.
Then, why this has happened after you have, your father had died? He never wanted that money. He may have thought that let the government be happy. Did he submit a representation during his lifetime?
No, no, madam.
Then, why should this court entertain this petition at all? When your father never wanted to burden the state, why are you burdening the state when your father retired in 2008? Isn't it? Take all this ground in your reply.
Yes.
Miss
R.S. Deori, ma'am.
R.S. Deori appears on behalf, Mr. H.R. Mr. K.R. Padgiri appears on behalf of the petitioner. Mr. R.S. Deori appears on behalf of Soil Conservation
Conservation.
Department. Anybody else? Ms. A. Talukdar
For respondent number 2, Lordship.
appears on behalf of the respondent number 2. And here appears for AG.
Respondent number 4.
AG. And finance? No finance. Okay. Anyway, yeah. Ms. R.S. Deori admits that she requires an accommodation of 2 weeks for filing the reply. It's the matter on 17th of May 2023. The issue of maintainability shall also be taken into consideration in the next.
29.
Lordship, in this matter, my learned friend provides me a copy of the requisition on the last occasion, Lordship, and thereafter I furnish it to the department. Although the written instruction is still awaited, but my verbal instruction is, Lordship, the service of the petitioner was provincialized based on the soft copy of the District Scrutiny Committee recommendation. And however, when the hard copy of the District Scrutiny Committee recommendation received by the government, the name of the petitioner was not there in the recommendation list.
In the hard copy, it is not there.
Hard copy it did not appear, however,
But soft copy, it is there.
soft copy it was there. Based on the soft copy, the service of the petitioner was provincialized, but in the hard copy it was not there. So now the process is on. There was a person hearing was also given to the petitioner
Then,
in this respect, and in that personal hearing, the petitioner appeared, but he did not prove his case.
so in the soft copy, it is still there.
It was there.
No, it is still there.
That particular
Have you removed it?
that verification is going on. They are making a investigation into that. So now, Lordship, the process is.
You want how much time? That is what I get up. Yeah. Mr. P.N. Sharma. The Learning Council appearing for
Elementary education department.
Elementary Education Department 6 for a accommodation of 2 weeks. This is the matter on 8th of May 2023, on which date? No, please stop. The Elementary Education Department, on which date? This is the matter on 8th of May 2023, on which date the Learning Council appearing on for the Elementary Education Department shall apprise the court with concrete information as regards the entitlement of. What? What do you want? Okay. You mention it on that day. We'll look into it.
30.
Yes, Mr. Rabha, wait. Yes, what is this matter about?
My lord, regarding pension, my lord,
Oh,
the person worked for more than 30 years, my lord.
hmm.
And my lord, your lordship directed the finance as well as BTC to take the instruction.
Hmm.
And they possibly got one instruction, BTC.
Your Lordship, today's morning, Mr. Rabha has to rush to Delhi, Your Lordship, for a meeting with the Prime Minister, along with his chief executive member of the PTC, Your Lordship.
Okay.
And Your
Then,
Lordship, he wants to submit some of the documents, Your Lordship, to the court, Your Lordship.
what
May
is
I, Your
that? What is P post?
Personal posting.
This is all because of Upenda's problem as a reason.
No, mother. What happened, mother? These people, they are working prior to 1993, 1/4/1990, but their service were not regularized. They left behind. Now,
Understood. You were not regularized. Everything I have understood.
Ma'am.
But you got the Upenda's benefit.
mother, no.
No, why it is given out here? Personal post. Upendas, you must have got later on. He was appointed as free post and he retired from service on 11/2020 after
20.
attaining 60 years. It is worth mentioning that the government order for appointing free post under reference does not provide any direction to pay pension benefit to any free post workers for which. If you work, didn't you get the pension benefit of Upendas? A casual employee who in a non-sanctioned post having been working for 10 years?
My lord, possibly not. But my lord,
No, otherwise, where is the question of personal post? If the personal post happens because of the Upenda's business. That is why these people were being paid.
I have to take instruction.
I'll fix this matter with, when did I fix the item number 1? I'll fix it on time. Heard Mr. G. Boyster, the learned counsel appearing on behalf of the petitioner. Mr. You take this. Mr. Your name?
DJ Bora, Your
D.
DJ Bora.
DJ Bharali.
Bora, sir.
Bora appears on behalf of the PTC. He has produced a set of instructions during the course of the hearing. The learned counsel for the respondent, the BTC, has produced a set of instructions during the course of hearing. This court deems it proper that the same needs to be brought on record by way of an affidavit so that the petitioner is in a position to rebut to such allegations. Taking into account the same, let the matter be listed on 10th of May 2023. The BTC is directed to file their affidavit by 3rd of May 2023. The petitioner, if so advised, would be at liberty to file their reply.
May I submit one thing? They bring instruction regarding the applicability of Prem-Singh judgment.
Huh?
Prem-Singh judgment, madam, wherein it was categorically stated that person who are working for more than 30 years, casual worker or master role employee, they are entitled to pension. So on that also they bring some instruction.
No, whatever may be, let them do it. Whatever may be. Where is the Prem Singh judgment?
Madam, last occasion, madam, I have.
Prem Singh, does it say
Yes, madam.
that a person who has been working for 30 years would be entitled to pension?
Yes, madam. That is para 36.
Where is Prem Singh? You have a copy? Give it to me. Para
36, madam.
33.
36, madam. Yes,
36.
36.
Some of the employees who have not been regularized in we will look into it because this seems to be an order passed under 142.
Madam.
The difficult
ma'am.
thing for this
Right,
court
ma'am.
to do. Yes, Mr. Naik.
This judgment only, Lord.
Ah.
Dear Lordship, in that judgment, Uma Devi was taken care of. And in the judgment, 3 conditions of Uma Devi was also noted, Lordship. Subsequently, when the order was passed, only 2 conditions were realized. Subsequent to this order, Lordship, another judgment came up, Lord. In therein, Lordship, court clarified, all the 3 conditions have to be fulfilled, only then you are entitled to regularization. The judgment is there.
No, because don't you think that paragraph is an exercise of power under 142?
It is not mentioned.
No, not mentioned, but you get the flavor from it.
But
The
thereafter
court, the
also-
Supreme Court has can pass such orders under 142. But can the court, this court
142
pass
is there,
this?
Lordship, but once the Uma Devi judgment is there, Lord, the constitutional bench is there. This would not have possible, Lordship, but it was discussed later on, Lordship. In subsequent judgment, these judgments was also relied upon. and-
Because Uma Devi said one-time measure.
Yeah.
But one-time measure, can you keep on making that one-time measure for every time to come?
Forever,
It
no.
will have a serious consequence. Because if you see Justice Emarsa's judgment, which says about 30 years, that is also saying 30 years continuous service in some regular post or
That's 30
something.
years in the context of Gujarat pension rule, Lordship.
But that also has a something to the effect,
Lordship,
regular or
in
confirmed or
that-
something
that-
to the.
That provision was there itself in the rule itself, Lord.
But it is just a 2-paragraph judgment.
Lord.
Anyway,
And in this
let them
case,
file their
Lordship,
reply.
this is
We'll look.
out- This paragraph 36 are out of context. Lord. I mean, all the petitioners are regularized employees in this case. Lord. And the issue was whether the master role or worker period can be counted for qualifying service or not. That was the issue. And this paragraph all of a sudden came in law. Lordship will,
And these were, it was held that master role workers, they were normally, or work charge or employees are specific to a project.
Not.
And as they were not This was not done because if you see the, I don't know here whether you have a work charge employees act, work charge establishment act. Do some doesn't have, but in Nagaland they have. In Nagaland they have defined who is a work charge employee, who is a master role worker. In work charge, it has been mentioned that these are persons who are specific to a particular department for a particular period. These are more tenure posts. Hello. Let them file the
Of the other judgments or subsequent judgments.
So that we can respond to it, madam.
Lordship, all the petitioners have been accommodated as teacher, tutor, but petitioner number 1 and petitioner number 4, they
Right.
did not join.
1 and 5 not joined, 1
1 and
retired and
1 and 4. And all the 4 are getting salary also, Lord. Drawing salary.
Yes. Petition number 1, Prasanto Saikya and Rini Saikya did not join.
Lordship. And rest 4, they are drawing their salary since February 2021.
so for my information, Lordship, Prasanto Soikia and Pontun Hazarika, they refused, my lord. And 1 retired, my lord. We failed to contact him, my lord. And 2, my lord, failed to contact, my lord.
No, they were given appointment letters. The others were given appointment letters.
But maybe in a written form, my lord, so that we can reply.
Prasanto Saikya, petition number 1 did not join,
Lordship.
but Anokanta Bora, he was given Montun Hazarika, he was given number 5. Then Uttam Kumar Dey was given and Mrs. Bornali Dotto was given, as well as the other 2. Rini Saikya and Prasanto was given as tutor. Where is the other portion of your
Lordship,
instruction?
that appointment letter is not here today.
No, it is there to annex.
No, only they have, although it is shown to have annexed, but in soft copy, Lordship, only the this letter has been received. We received through soft copy, Lordship.
What was the matter pending before the Supreme Court? In the appointment letters, it has been said the appointment is made subject to the result of the CR pending in the Honorable Supreme Court of India and the Honorable High Court. But they have been found to be excess teachers.
Excess teacher. Excess teacher.
Excess or illegal?
No, no. That those irregular illegal teachers, Lordship.
Irregular illegal teachers, not excess.
Lordship. Irregular illegal teachers.
Were they being paid some stipend? And whether they were put against some supernumerary post?
Lordship, they were put on the supernumerary post. It is stated here, Lordship. With reference to some-
It was open by the GF. Period of service has been regularized
who
by
were
giving
appointed
GPF,
establishment
PF, opening the service group, efficiency for everything, man. Not
The-
illegal, irregular, my
The
lord.
post of
It is their
1,005.
version, my lord. So it is my humble prayer, your lordship, my lord. Whatever the extent taken by my learned brother, maybe in written form, giving us the opportunity to reply, my lord.
Let them put it on affidavit.
My lord, we can accept. This is not the way, my lord, as adopted my learned brother, my lord. It's been type.
The post of 1528.
You file your affidavit
Lordship,
because against 1 and 2, 1 and
1 and 4.
1 and 6, 1 and 4.
4.
Others have duly accepted.
Not duly accepted, my lord. My lord, let them 7 years no reply, my lord. Individually they issue before the court to issue an individual so cause notice and a speaking order. Till that, no, nothing, my lord. 7 years kept mum, my lord. After 7 years, my lord, they introduce a, my lord.
Understood. No, Mr. Mr. Ahmed, I'm putting it like that. Don't
My
worry.
lordship, my lord.
Heard Mr. M.U. Ahmed, the learned counsel, appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the Elementary Education Department. Today, Mr. P.N. Sharma has produced an instruction issued by the Director of Elementary Education dated 10th of April 2023. In terms with the instruction, it has been mentioned that the petitioner, the appointment of the petitioner were categorized as illegal or irregularly appointed teachers. And by way of a cabinet decision in the meeting held on 7/10/2020, all the 6 petitioners were issued appointment orders on 30/1/2021. It has been further mentioned in the state communication that out of the 6 petitioners, the petitioner number 1, 2, 3, 5, and 6 were accommodated as teacher, whereas the petitioner number 4 was accommodated as a tutor on the basis of the government instruction dated 21/1/2021. It has also been mentioned that pursuant to the appointment orders being issued, the petitioner number 2, 3, 5, and 6
Lord.
have duly joined their respective schools
On February 2021.
on February 2021 by submitting the joining report as well as giving the undertaking as per their orders of appointment. However, the petitioner number 1 and 4 have not accepted those appointment orders. Mr. M.U. Ahmed, the learned counsel appearing for the petitioner, submits that he would like to take instructions in respect to the said aspect of the matter. It has been also submitted that the fact that the petitioners have been categorized as illegal or irregularly appointed needs to be mentioned by way of an affidavit so that the petitioners hearing, more particularly the petitioner number 1 and 4, can refute to such allegations. Taking into account the same, list the matter again on 12th of May 2023. The Elementary Education Department is directed to file their affidavit by 4th of May 2023. So the petitioner, if so advised, could be at liberty to file their affidavit in reply on or before the next date.
After receiving the copy or before that?
No, you can file your reply only after that.
Okay, so
I have directed them to file by 4th of May.
for all the petitioners, my lord, because of the inequality bargaining power, my lord, somebody may accept, my lord.
Understood.
My lord.
That is why I say more particularly.
Right.
Because those 1 and
Yes,
4
yes.
have not received, no?
So beggars have no choice, lord. 20 years of service, my lord, for one man. So, my lord, after
The
receiving
communication
reply-
so placed by Mr. P.N. Sharma is kept on record and marked with the letter X.
13,
Reply.
Mr. Sharma, you bring on record those joining reports and all. Yes,
Lordship, petitioner has not received his pension till date,
you have not received.
not received.
Gratuity? No.
No, lord.
Yes. Who appears for the treasury?
Lordship.
You have done your job.
Yes, sir.
Only the
Lordship, in respect of GPF.
GPF.
GPF, Lordship, I have received the instruction, Lordship. The office, we have returned the file because incomplete. There is a GPF application was not forwarded along with the other documents, Lord. So department has to
Where is
forward.
the finance? No finance. Oh. We ask the treasury officer. He's causing the problem. In spite of your, I think your letter must have gone to the treasury department.
Yes, Lordship, I have submitted email to Lord.
Huh?
Learned Council last occasion also I have forwarded the copy, Lord.
Yes. No, you have already stated, directed that forwarded the PPO
Yes, sir.
as well as
PPO
also the
and
direction
computation
to
of
pay the 6,12,000 to the petitioner on account of gratuity.
Lordship,
Have issued another communication for the purpose of pension.
Lordship.
That is on 9/2/2023. And
Lordship.
why the petitioner have not received?
And
When did you inquire?
Lordship, I inquired last week also and today also I inquired, and he already visited the office of treasury. Due to some this year ending, Lordship, maybe the treasury has not released it payment pension.
Okay. Okay, none appears, huh? Heard Mr. S. Sutradhar, the learned counsel appearing on behalf of the petitioner. Mr. R. Talukdar, R.K. Talukdar appears on behalf of the Accountant General AE. None has appeared on behalf of the Treasury Officer, Hatsingi Mari. On call.
It's not a party.
Huh?
Lordship, the finance is the party. Finance is the party.
Finance is the party, that is it. None has appeared on behalf of the Treasury Officer Hatsing Mari, which is normally represented by the Finance Department, who is the respondent number 5 to the instant proceedings. In the order dated 13/3/2023, this court had duly recorded that the Office of the Principal Accountant General AE have already issued the PPO as well as also communications dated 9/2/2023 for the purpose of payment of the pension to the petitioner as well as the DCRG. The learned counsel appearing on behalf of the petitioner submits that as of date, none has happened and he has not received any pension from the office, received any pension pursuant to the communications dated 9/2/2023. And in fact, the petitioner have also visited the office of the Treasury Officer Hatsing Mani. Your account is there in which state bank?
Most probably in the thing, I have to insert.
The payment will go from there to the state bank, na?
Yes, sir. He set his account also, Lordship. In morning, he wanted the,
Where is his account? That you don't know.
that I don't,
First time doing a pension matter.
yes, yes, sir.
That is why the result. Next time you inquire, which is the bank account?
Sure.
The petitioner is directed to serve the Treasury Officer Hatsing Mari is directed to do the needful in terms with the communications dated 9/2/2023 issued by the Office of the Principal Accountant General AE Assam forthwith. The petitioner is directed to serve a copy of the instant order to the Treasury Officer Hatsing Mari. As regards the question, as regards the entitlement of the petitioner on account of GPF, the learned counsel appearing on behalf of the Principal Accountant General AE had submitted that the file had to be returned back, the proposal had to be returned back on the ground that the in charge have not forwarded the GPF claim form B. Who does it?
Lordship, the Department Director, Information Related Public Relations.
Huh?
Department, respond number,
Just in the letter
Three.
addressed to the
respond number 3, you know,
Response
Subdivision Information and Public Relations Officer, South Salma Hatsing Mari. To British.
Mr. D. Bora appearing on behalf of the respondent number
1, 2,
1, 2, and 3
and 6.
and 6 submits that necessary steps would be taken for the purpose of sending the proposal, sending the necessary steps should be taken for sending a complete proposal within a week. Let the matter be listed again on 8th of May 2023, on which date the learned counsel for the petitioner as well as the respondents shall apprise this court as regards as to whether the petitioner have already received the pension and the DCRG, as well as the status pertaining to the entitlement of the petitioner on account of GPF. The instructions were produced by Mr. There are two copies. You want one?
Lordship, one letter is addressed to me and next letter is also a reminder to the department, Lord.
The instructions were produced by Mr. R.K. Talukdar is kept on record and marked with the letter X. Why?
Bank name is State Bank
State Bank of India.
Abhayapur. It's at page number 25, pension papers itself mentions the State Bank, the bank.
Bank name?
State Bank of India, Lordship, page 25, Lord.
Abhayapur.
It's okay. I think you inquire the State Bank then.
15.
Plus,
Your Lordship.
Yes, Mr. Devnath. You file your affidavit.
No, madam.
Huh?
You're supposed to get instructions, madam.
What is this? Mr. N.K. Devnath, the learned counsel appearing on behalf of PNRD, submits that he requires a further accommodation of 2 weeks. Tell me, who has filed affidavit? Respond number 10. Who is respond number 10?
We have filed the affidavit, madam.
You have filed the affidavit. Then
I was talking about the instructions, madam. That's short,
what instruction?
specific instructions, madam.
Oh,
One was as to
no,
whether
notice. Okay. Yes, here is why the petitioner's name was not included in the office order dated 14/12/2021. Where is that 14/12/2021?
Your Lordship.
Yes, 14/12/2000 regarding contempt.
It's page number 53, Lordship.
the reason is given at page 51, madam. Para number 1. Fourth para, madam.
Yes,
Annex L.
one of the petitioners of contempt case, Sri Boluram Gogoi. What is that? Name could not be sent to finance department as he was engaged in post FRBM period.
This is the ground for rejection, madam.
Understood. But FRBM or whatever may be, Upenda's categorically mentioned that a person is entitled to, if he has worked for 10 years from 1/6/2000, 1/8/2017. Isn't that so?
So this list was actually prepared post.
No, you have left out, it is a different thing. That is why I asked you, why have you left out? I know that is left out. That is why the order is, this is the order of 14th of December 2021. Why have you left out? If he had already had this 10 years, isn't that the Upenda's case? Where is the Upenda's judgment? You have enclosed, Miss Madam. That is the instruction I've asked for. Why you was left out?
This is all I could get, madam. This was given to me. This is the reason that was given to me, madam.
Why?
That my lord, his name was rejected on the ground of irregular appointment post AFR BM, madam.
Irregular?
Yes, madam.
What is this irregular business?
Exactly the
No, no, what is this irregular business? Irregular has to be based on something. There was no selection. Because Upenda says that a person concerned who has been rendering 10 years of service in a non-sanctioned post would be entitled to the benefit. Your case is a minimum of scale of pay.
Yes, Lord.
Yeah.
And similarly situated person,
That is why this court asked you on the last occasion.
This is all the inspection I am, madam.
Hmm?
This is the only inspection I am. The reason given is the ground of irregular appointment.
What is the
They
date of
haven't
your
even explained
instruction?
as to what is the irregular appointment.
No, why why are you saying it to be irregular?
Explanation to that effect is not given, madam.
Irregular is mostly when an appointment happens to a non-sanctioned post. If an appointment happens on a non-sanctioned post, that is an irregular appointment.
Correct.
Isn't it? That that is why I made it clear in my order of 1/2/2023 as to why the petitioner was not included in the office order dated demand. Those similarly situated persons like the petitioner have been duly included.
As of now, madam, this is the only instruction I have.
Huh?
This is the only instruction I have.
So you want the commissioner to be present?
Madam, may kindly give me time till tomorrow, madam. Tomorrow I'll.
This is the only instruction I am asking it.
There was one more, madam. As to whether in the annexure to the document dated 1/2/2018, the petitioner's name is included or not.
No. It is not included. Why? That is my question. Have you seen my order of 1/2/2023?
No, madam, I have a
That is why.
But madam, if I.
What instructions are you seeking for? Here I have made it clear. The learned counsel appearing on behalf of Panchayat and Rural Revenue is directed to verify the contents of the communication dated 1/2/2018 issued by the commissioner and so as to whether in the annexure to the said document the petitioner name is included.
This I've seen, and this has been communicated to the department, madam.
Okay, then further to that, the learned counsel for the Panchayat and yes shall also apprise this court on the next date as to why the petitioner's name was not included in the office order dated 14/12/2021. Those similarly situated persons have been included.
I've gone through this, and this has been communicated. The instruction as I've received, I don't know, is only this, which I've stated right.
Yes.
That is the instruction only I have. But as far as my lord, whether the petitioner's name is included in the annexure to the said document or not, my lord, if my lord will have a look at page 49, my.
Page 49.
Annex.
Yes, 49.
At the bottom, my lord, along with this letter, communication, there are two enclosures. Enclosure 1 and enclosure 2.
What is his name? Baluram Gogoi. Enclosure?
There is mention of two enclosures, my lord. Enclosure 1 and enclosure 2. Now, if you come to the second para, my lord, fourth line, fourth sentence, the fifth sentence, beginning from the sentence beginning at the fourth line, my lord. Annexure 2 happens to be the order dated 8/6/2017 passed in writ appeal number 45/2014. Whereas annexure 1, which is mentioned just at the beginning of that para, it says that, however, this actually annexure contains names of a list of cases, names of casual workers, actually bunch of cases related to casual workers in which directions have been passed by the Honorable Court, my lord. Along with this list, in this list, my lord, if my lord will have now come to the third para, my lord. There is a reference to a contempt.
Yeah. You see at page 50, annexure 1.
Yes, my lord, it's there.
His name is there.
It is there, my lord.
Then why you have removed him? While giving appointment to giving all the other people, Jugeshwar, Nath and all. That is the reason why this court has asked. This is a annexure to 1/2/2018.
Yes, ma'am.
In annexure to 1/2/2018, the petitioner's name is there. having more than 10 years
It is,
because he was appointed in 2005. So as on 1/8/2017, he had the 12 years.
but what I've stated, my lord, that was the reason, my lord, and that has been actually stated in the affidavit also. This is the reason actually why his name was not,
Huh?
why his name was rejected.
Why?
That's the reason, my lord, which I've stated, my lord, which is also mentioned in the affidavit. At para 5, my lord. Page 56.
Affidavit filed by
Respondent number 10.
yes. Where is it?
Page 66, my lord, para 5.
Para 5
Five.
was rejected the name of the on the ground of irregular appointment post FRBM. But can you do so? If that is the reason, can you do so when Upenda says that to give it to anybody else? Because Upendas does not further specify that there has to be something taken with the heir, because that was a judgment in 2017. And in 2017 also, they have put the benchmark of 10 years.
And they have filed a reply, my lord. In the reply, they have actually stated that this particular reason of ours.
Hmm.
See at page 70, my lord. Para 6. Not the para 6. Yes, my lord, para 6.
Para?
Para 6, my lord. My lord, para 5, actually. Para 5. At page 59. This is the response they have given, my lord. And also para 6 on the next page.
Para 6. No, whatever may be, it does not say anything what to do. Now, what is this order of contempt petition?
This contempt case, my lord, arises out of a writ petition.
Or that order?
Order dated
The order dated month passed by
31/5/2017, madam.
Okay, where is 31/5/2017 order?
Next date is 42.
Huh?
Annexure level, page 42, my lord.
You see, whatever may be your issue out here, what you have stated is that the petitioner has not been given because on 4/7/2025, 2005, the AFRPM Act has come in. So once that act has come in, any appointment has to be made with the finance SIU approval. That is the act.
Yes.
Now the petitioner's appointment happened then.
Appointment was
No finance. The finance is not coming up.
his appointment took place on 6/2/2021. It's at annexed D
6/2/2020.
6/2/2020. Yes, sir.
Whose appointment?
The petitioner.
No, 2005.
Yes, sir. 2014, man. 22/1/2014. That's
No, it is
Balaram
certificate,
Gog's
Lordship.
appointment.
No.
This is the certificate issued
You have
of
not read the brief properly.
Sorry, madam.
His appointment is of
22/9/5.
22/6/2005.
Yes, Lordship.
Oh, 05.
Mr. Nayak, tell me one thing. Upendas says Upendas was a decision delivered after 2017, in the year 2017. And in that case, it has been mentioned that those people who are there, casual employees or are not in sanctioned post, for a period of 10 years prior to 1/8/2017, would be entitled to the minimum of scale of pay. Now here the petitioner has not been granted, though there is no quarrel with the proposition that the petitioner is there in service, on the ground that he was appointed without taking the AFRBM Act.
At a prior or subsequent?
This has been said to be after. This is the reply being given by the Panchayat.
Going by the Upenda's direction, Lordship, it is 10 years still prior to 2007. But Finance Department issued notification there. They have said those who are appointed prior to FRBM Act, that is September 2005, they will be given the benefit of.
So Finance Department have gone against the judgment of the.
That situation we have not faced yet, Lordship.
Huh?
That situation we are not facing yet, Lordship. If this question arises, Lordship, then definitely we have to answer.
Because otherwise, if that be so, then it would be contrary to the judgment of the division bench.
Yes, that we also feel.
Hmm?
We also feel that, but for that, Lordship, we have to
The
prepare.
irregularity is only on the basis that the AFRBM Act has come in and his appointment was appointed without taking his concurrence. That is the basics. That is the irregularity. Otherwise, there is nothing out there.
Presumption is that, Lordship, FRBM Act laid down certain norms, Lordship, as regards recruitment. And
But FRBM Act came in 2005.
Yes.
Irrespective of 2005 Act having been coming in, this court did not say anything to that effect
that was not the case.
and said that whoever it is, this is the benchmark we are putting as on 1/8/2017, 10 years before, everybody would be given.
But of the record, Lordship, some employees from the PNRD itself, Lordship, have got the benefit, though they were appointed subsequent to FRBM. That instruction, at least I have.
Mr. Naik, you kindly take this instruction because this is the basis and it is the finance who has to look into this. They are saying it because there are, what has happened, there were 10, 11 petitioners whose name was also there. If you see, let him show you a particular document. That is annexure page 49, annexure 1. Page 49, Annexure I. See this, there is Annexure 1. We are concerned with Lakhimpur. Now here the case out there is at serial number 108, Balaram Gogoi. This person was appointed on 22/9/2005. His period of service is more than 10 years. Madam, another thing, you just find out whether these people have been appointed, have got the minimum of scale of pay.
Yes, Lord.
Those person at just, for example, at serial number 89,
Yes, Lord.
90,
Yes,
have they
Lord.
got it?
Yes, Lord. This person have got.
At page 50, those at serial number 89 and 90, have they got it? These are all 2006. You take your instructions, Mr. Naik. I'm fixing it. I'm detailing out what is necessary to be found out. Heard Miss
B Talukdar.
P. Talukdar.
B Talukdar.
B. B. Talukdar, the learned counsel appearing on behalf of the petitioner. Mr. N.K. Debnath appears on behalf of the PNRD department. Mr. P. Naik appears on behalf of the finance department. Finance is the party?
Not.
Oh, yes, finance is there. On behalf of the finance department. The case of the petitioner herein is that the petitioner was appointed on 22/9/2005. And as per the judgment of the division bench in the case of State of Assam versus Upendas, the WA number 245/2014, dated 8/6/2017. There was a direction upon the respondent state that all persons working in all casual appointment. What is the term used in Upendas?
Master road, worker, and similarly placed casual work.
Casual.
Yes.
Casual master role
Master road, worker, and similarly placed casual work.
and similarly placed casual workers appointed in non-sanctioned posts would be entitled to the minimum of scale of pay. Who have been rendering service continuously for more than for 10 or more than for 10 years. For 10 years, na? For 10 or more years. What do you have that? That's paragraph 22.
Yes, sir.
10 years.
More than 10.
Who have been rendering service since last more than 10 years, bracket not in sanctioned post, with effect from 1/8/2017, 1/8 or 1/6? 1/6 or 1/8, na? It is 1/8/2007, 1/8/2017. The claim of the petitioner, however, has been rejected, as could be seen from the affidavit filed by the respondent number 10, on the ground that the appointment of the petitioner was irregular appointment on account of post AFRBM. This court, upon hearing the learned counsels, had raised a specific query upon the learned counsel appearing on behalf of the finance department as to whether the directions passed by the division bench in Upenda Supra is not required to be complied with. If a person is appointed post AFRBM period, more so when the division bench of this court did not distinguish at paragraph 22 of the side judgment in respect to persons who were appointed post and prior and post the AFRBM period. List the matter. Further to that, this court shall also directs the learned counsel appearing on behalf of the Panchayat and Rural Development Department as to whether the petitioners in WPC number 1357/2016, whose names are reflected at page number 50, bracket annexure 1-2, the communication dated 1/2/2018, are receiving the minimum of the scale of pay as directed by the division bench of this court in Upendas. List the matter on 8th of May 2023. Liberty is given to the petitioner to mention the matter for updating. Mr. Devnath, you get your instruction. Next time you don't come up with this thing again.
That's good.
The petitioner's appointment date is 39.
Yes, Lordship. Initially, he was appointed on 22/06/2005 during the time of his father, and thereafter he appointed on 22/9/2005. Public.
17.
Yes, Mr. Beltrame.
Matter relates to Lordship, non-payment of pension. Lordship.
Talukdar.
This case, Lordship. Sorry, I'm sorry.
Hmm.
Last occasion, my
Yes,
lord,
Mr. Beltrame. Means the department has sent the proposal in.
pension proposal already forwarded to the AG.
Yes,
My lordship,
yes, Mr. Dhar.
yes, we have received the pension papers, lordship, which
Yeah.
was sent on 4/3/23. Process is there under pension case is under process, lordship. And I'll apprise your lordship in the after vacation.
Okay, we have it on 15th of May.
By the time I think PPO will be issued.
Mr. Adhar, the learned counsel appearing on behalf of the petitioner, on behalf of the accountant general AE, who submits that the pension proposal of the petitioner has been duly received, and he shall provide the up-to-date status. And he seeks for some accommodation for providing the up-to-date status. Let the matter be listed again on 15th of May 2023, on which date the learned counsel for the accountant general AE shall provide the due instructions.
Obliged.
Liberty is given to the petitioner for mentioning the matter for update.
Obliged.
18.
Yes, madam.
Lordship, the instruction that I received is that a proposal has been sent from the inspector of schools to
Okay,
the director of secondary education office, Your Lordship, and it is under process, Your Lordship,
proposal for what?
for area salary, Your Lordship.
Okay. Area salary from 6 to, oh, your date to Google has not received the area salary from 8 to fulfilling.
Kindly see last order 17/3/2000.
Yeah, the area salary from when to when?
For the period
From-
15 February 2006 to 23rd of April 2005.
2005.
There's mistake.
Oh, it's a mistake.
That is what I'm saying.
2008, Your Lordship.
8 Lord, it should be 8.
Okay.
23rd of April 2008.
I'll plug on my. Heard Mr. A. Deka, the learned counsel appearing on behalf of the petitioner, Ms. D. Musari,
Lordship.
appears on behalf of the elementary education department as
Lord,
well as the secondary
secondary,
education
Lord.
department.
Lord.
This happened because of the school upgradation. huh?
Lordship, it's got another.
The writ petition has been filed, being aggrieved by non-receipt of the area salary for the period from 15 to 2006 to 23/4/2008, isn't it?
Yes, Lord.
Ms. D. Musahri, the learned counsel appearing on behalf of both the elementary and secondary education department, submits the proposal has already been sent to
It's sent to the office of the director of secondary education.
Director of Secondary Education. And the same is under process. List the matter again on 17th of May,
Lord.
on which date the learned counsel appearing on behalf of the elementary as well as the secondary education department shall apprise this court as regards the status it is made clear that the instant writ petition was filed in the year 2022 and notice was issued as far back as on 11/3/2022. Under such circumstances, if no concrete information is received on the next date, this court puts the notice, puts the elementary as well as secondary education department on notice as to why interest should not be imposed upon the concerned respondent authorities for delay in payment of the area salary of the petitioner. Area salary.
Arrears, Lord.
Obliged, my lord.
Proposal, Lordship.
Regularizing of which period?
The under period, absent period, 2003 to 31/7/2012.
So now it has been sent. Without regularity.
Yes, Lordship. That's right. So they have said they have sent it back to them.
Lord, let me have to instruct the Lordship, perhaps the department has sent back.
Already we have filed our affidavit, Lordship. In the affidavit also we have stated
They are receiving the provisional pension.
Only a lump sum total of rupees 4,960 lot. And I have not received even the provisional gratuity lot.
Hmm?
Provisional gratuity are also not released. I'm getting it from Lordship June 2022 lot.
Now you were absent, unauthorized absence from 1/1/2003 to 31/7/2012.
Lordship.
Then you again joined.
Lordship.
You were allowed to join,
Lordship.
and you retired
Retired lot.
in 2014.
2014 lot.
And there were no disciplinary proceedings.
So Lordship, my leave was not unauthorized, Lordship, unlawful Lordship, arrested due to the illness, TB leave, Lordship.
Huh?
TB. I was suffering from TB and mental Lordship, mental disorder also Lordship. My leaves were granted Lordship, but that was not regularized. Followed by government approval Lordship, perhaps Lordship, but leaves were granted Lordship. The authority aware about my leave Lordship. Some leaves are granted with pay and some leaves are granted without pay Lordship. I have annexed. Annexer 8 series Lordship, may kindly come to the page number 28 onwards Lordship.
Yes, to me.
Lordship.
Let us see. There is an affidavit filed by somebody.
yeah,
Who has filed this affidavit?
on
By
behalf
the
of respondent
Commissioner
number
of
3,
Pension.
Lordship.
That is the says leave
Yes.
without pay was granted to the petitioner from so and so to so and thereafter his pay was held up with effect from March, and leave without pay was granted to so and so, that is more than 5 years. Further, no medical service was submitted with the proposal. It was not clarified whether he was removed from the state disease or not. It is pertinent to mention as per appendix 30. You were appointed when?
On Lordship 5/9/1979 Lord.
and you have the pensionable service.
Lordship, more than Lordship, 34 years service.
Huh? 34 years?
34 years service.
You were not there for quite a long time, 9 years.
Lordship, due to Lordship, severe illness.
But then
Lordship.
also, whatever may be,
Lordship,
you have the service.
Lordship.
9 years also, if you
Time
deduct
to
it
time,
also.
Time to time I joined also, Lordship. Time to time I joined also.
You joined also.
Lordship,
You were allowed to function.
Lordship.
Where is it?
Lordship, may kindly come to the page number 27.
Page?
Page 27.
Yeah. 27 is in
Page
Asmi.
26.
We hereby to inform that for the date of birth of the service. For release of benefit at Mr. That is okay. But where is it you joined in the meantime?
Release order to them.
Hmm?
It's a release order.
Lordship, I have stated it in my petition, Lordship. Paragraph number 6 of my petition, Lordship. That the petitioner begs to state that in the year 1989, he was suffering from TB, for which he applied for leave and accordingly filed order number so and so dated so and so. With effect from so and so, his TB leave was granted with full pay. And
So
order
the
dated
problem
number
arises because of the director of elementary education.
Lordship.
Yes, Mr. Sharma. You are at fault.
Lordship. Lordship, here the even the service book is also not very complete. There is no complete service book.
Service book is not there, it is a different aspect, but the fact that you have sent the service book is also apparent. Kindly see.
Lordship,
No, kindly, no. Kindly see his instruction which he has given today. See the last page. Last page of his instruction. The original service book, 5 numbers. You see the last page.
Lordship, where?
Last page of his instructions.
Here only one.
Only I have front page, Lordship.
This government have gone eco-friendly, not to take further printouts. See out there, the director of elementary education have sent the service book.
Lordship, the original service book.
So why haven't you not regularized this period? Either you regularize, omit, whatever may be, but the petitioner has been waiting out there from 2014, have not got his pension.
Lordship, let me have the instruction.
Appointing authority has to move to the PPG department for that regularization.
Huh?
Appointing authority has to move to the PPG department for regularization.
Whatever, does it take for 9 years for doing that? They know to send up a pension, it is requires to be done. You don't regularize is also another aspect of the matter. You don't regularize, but then also he's entitled to, he's from appointed from 75.
79.
No, 79 to 99, it's 20 years. He has a pensionable service. Then heard Mr. H. Talukdar, the learned counsel, appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the Elementary Education Department, and Mr. S.R. Borwa appears on behalf of the Directorate of Pension. Mr. S.R. Borwa, the learned counsel, has drawn the attention to a set of instructions given to him by the Director of Pension, wherein it has been mentioned that though the pension proposal have been sent by the Director of Elementary Education Assam on 7th of February 2023, but in doing so, the Director of Elementary Education have not regularized the period of unauthorized absence of the petitioner from 1/1/2003 to 31/7/2012. And it is under such circumstances, the petitioner's pension could not be fixed. It is relevant to take note of that the petitioner was initially appointed in the year 1979. And thereafter, admittedly, the petitioner have rendered service till 2/6/1999 with full pay. Thereupon, the pay of the petitioner was held up. On the alleged ground that the petitioner was under unauthorized leave. It is also relevant to take note of that from 1/8/2012, the petitioner had rendered service. And it was on, when did you retire?
31st January 2014. 31st January 2014.
And the petitioner retired on 31/1/2014 on superannuation. The petitioner thereafter have been running from pillar to post for getting his pension as well as his pensionary dues, pensionary benefits. During this long passage of time, which is almost a decade, the petitioner has been given a meager amount of rupees
4,960 Lord,
4,960 as provisional pension per month.
from June 2022. Lord.
That too from June 2022. This court fixes this matter again on 15th of May 2023. The Director of Elementary Education is directed to take necessary steps in that regard. So that the petitioner receives his pension as well as his pensionary benefits. You have to send that proposal can't work. You have to again return it.
Yes, yes.
The Director of Pension is further directed to forthwith return the pension proposal to the Director of Elementary Education, so that the Director of Elementary Education is in a position to send a concrete proposal so that the petitioner can get the benefit of his pension and other pensionary benefits. A copy of the instant order be served upon Mr. S.R. Borua as well as Mr. P.N. Sharma, the learned standing counsels, for doing the needful. Instructions so produced by Mr. S.R. Borua is kept on record and marked with the letter X.
20,
You can go. Mr. Bhardwaj, in this case, if we see the son of the petitioner was appointed in 2011.
Yes.
February 2011.
Yes.
And he expired during his period when he was in service, 2021. And because of that, he would obviously come within the ambit of the new pension rules. But he would be entitled to compassionate family pension.
Yes.
As per 14/7/2017.
Yes.
Now, in the compassionate family pension, although Madam did not include, if you see this particular petition, more particularly the 31st of October 2017
Relatives and kin.
office memorandum,
Yes.
if you see down below at page 20,
Yes.
family pension of cases covering death of government while in service appointed on or after 1/2/2005. Family pension is provisional basis to which the family of government appointed on so and so and covered by NPS so and so who have died in harness shall be governed by the so and so dated 14/1/2016. However, government service appointed under so and who died after 1/4/2017, we are concerned with this.
Yes.
Shall be governed provisionally by provisions as described in 1A3A of this guideline and in terms with rule para 5.9 of so and so of 14/9/2017.
Yes.
Now 1.3A, see,
Yes.
the government of Assam, government in the finance department, page 19.
Yes.
Department of so and so has come up with the scheme of compassionate family pension in lieu of compassionate appointment for those who have changes to so and so. As per the provision of this scheme, where the employee dies before superannuation after completing 1 year of continuous service, family pension equal to 100% of the last drawn of the deceased be paid to the family. You see, legal heir who have the eligibility to receive normal family pension as per the rules of 1969.
Yes.
For a period up to the date of deemed superannuation of the deceased employee, that is, the date on which the employee would have superannuated and had to be alive. The last pay drawn for this purpose is the last pay drawn with so and so over so and so will be entitled to so and so. Now, this is what is the scheme.
Yes.
Now, if you see the 14/9/2017, you have a notification that is not included out there. That is the problem which has happened.
My lord, I have.
Yes, only see 5.10.
Yes.
It is also provided if the parents or other eligible family members are not looked after by the compassionate family pensioner.
Yes.
On receipt of such complaint from them, the competent authority will issue order apportioning the compassionate area appropriately amongst the other family members.
Yes.
So this is what has been given out there.
My lord, if I may request your lordship to simultaneously come to the latest amendment of 2022, my lord, of 143, note 2, the inclusive D.
No, D will come later on. Where's the new book?
My lord, this scheme is for enhancement of the pension, my lord. This is not regarding entitlement. I am coming to the entitlement part. The person dies at 30 years old, he was to retire on 60. He will get a enhanced pension until the age of 60, his family will get it. And after 60, normal family pension will start. Now that scheme is regarding this aspect. Now again, this rule says that eligible family members are not looked after by the compassionate family pensioner. My lord, two aspects of this rule, my lord.
Hmm.
Not looked after, and
Hmm.
then again down below apportioning, my lord.
Hmm.
The competent authority apportioning.
Hmm.
And again, the latest amendment of 2022, my lord,
Hmm.
after the instant case was filed, it also says if the family pension recipient does not divide the amount among the other beneficiaries in equal share, and on receipt of such complaint from the eligible family members, the competent authority shall issue orders apportioning the family pension among the other family members. My lord, as on date, the pension has not been released to me. No one knows if I am going to actually give something to my mother-in-law or not. Second of all, if I don't give, my lord, she has to approach this court or the accountant general. That is the competent authority who is to apportion the pension, my lord. This is always the case, my lord. In the instant case, neither the pension department nor the accountant general, no one is party. Whether this scheme is applicable to the instant case or not, the pension is not here, department is not here, my lord. So my lord would remand the matter to the authorities. My only submission is that my lord would remand the matter to the authorities in light of these two rules, my lord. And the authorities shall decide after releasing the pension to me, provided I don't give anything to her. That is what both the rules say, my lord. I might also.
Mr. Borua, what do you say about this particular way, the 2022?
It was there in the latest edition of the pension.
But note 2 will only apply when the widower dies.
No, my no. Note 2 applies to the entire family, my lord. And within the definition of family, my lord,
No,
widow also comes, my lord.
start note 2 earlier. Read the note 2 on top. Yes.
Note 2 after clause C.
No,
my
note 2, read note 2,
E,
start
note 2,
the
E.
note 2.
my lord. The pension will be admissible.
No, why are you reading that? Note 2, start. In case where there are 2 or more family members, minor, son, unmarried dependent daughter, present at the time of death of the widow. That is why the problem arises with note 2. This aspect of the matter is not dealt with. 5.10 is not there. You are saying about D. Where's the D? There's no D here in this book. Give him a copy of that. What you have got it out there.
It's back. It's in my cell phone, my lord.
It's okay. You can give it to him. He can find it out. Give him the site. He will take it out.
My lord is right. It has to be after the death of the widow.
But problem arises with this. They should have made this D into a separate note. No, it is not done. They are still putting it in note 2. If you do it in note 2 only comes into action when there is a death of the widow. How do you take care of this? Here the family pension recipient would have to be mean the family pension recipient after the death of the widow. That would be a big problem. Mr. Barua, you get the, you see this problem? You can video. Let us take the benefit of Mr. Chaudhary sitting out there. Mr. Chaudhary, kindly see one thing. See, show him the note 2. Note 2 comes up in cases where there are 2 or more family members, minor, son, unmarried daughters present at the time of the death of the widower. The family pension as admissible shall be divided in all respects till the eligibility ceases or so and so. So this is okay. Now, what they have done, the government, A, B, and C, and now they have inserted D. D. A D2 note 2. Now, what is the problem which is happening? Note 2 only comes into effect when the widow dies. So note 2 only will come in. But what will happen at the time when the widow is alive? Can D will apply? That I've given it to him, that book here. Then, because this is a provision out there in this note 2. So how can you apply unless this should have been brought by way of another note? What they did, they have brought in as D. They should have made it note 3, note 4, note 5, note 6, whatever may be. Ah, can you do it? Die. Otherwise, if this was separately brought in, the question would have been different. Because otherwise, if you see, now if you see 143.2 at page 159 of that book, yes, at page 159 of that book, 159, on top, 149. This is the order in which the payment is to be made. I think you are reading the old book, old rule. There was an amendment at page, you have the new one? Ms. Bora, kindly give it. Page 159. The pension will be admissible in case of a widower up to the date of her, his death or remarry, whichever is earlier. Then comes in case of a minor. So there is an order by which the payment is to be made. Now by these notes, it is more clarification is being given. But note 2, yes, now note 2 categorically says down below, in case where there is death, then can you put the D to subserve the case of a general perception? No, because it is a part of D. No, it couldn't. Yeah, that is the problem with it. In fact, they should have made it note 6 or note 7, whatever may be the situation. But here we see. Yes. No, the moment we say that, you are, no, why I'm saying, the moment you say that, it will tinker with 143.2, wherein its first preference is given to the widow. The mother would be the eldest. Now, if you see 143 Kindly come to page 158 of that book. Yes. Now earlier, if we see this amount was initially 158. The first is the pay, how the wife in the case of a male officer, husband in the case of a female, minor sons, unmarried dependent. Yes, 158 down below. For the purpose is wife in the case of a male officer. You're getting it? The last line of that book. No. This is which you are taking Miss Bora's. Yes. Kindly some family definition. You have got the definition. Yes. Yes. One. This is unmarried daughter. Then what happens? You see on top, if you see 3 of that very book, no, D, they have amended, brought in D to the father. What Mr. Ramchandra Saikia has done with his book. The mother gets only when the father is not there. And mother is brought in as E. A, B, C, D, and E. After unmarried dependent daughters. Then after unmarried dependent daughter, it is the father. Then if the father is not there, then comes the mother. Then comes the elder surviving brother up to 18 years. And then comes the eldest surviving unmarried sister up to 21 years. Now the law is well settled that only one person is going to get the pension. Now if we bring in the note A, note 2A, which you have just read, giving it to the eldest, this will tinker with that. So it can't be done. Unless they bring it separately by a note, which they have done for the purpose of the compassionate family pension. Very difficult. Now, what is happening? The biggest problem which is being faced now is this. I hope you have gone through the full bench judgment. With due respect, there's a full bench judgment on this pension. The issue which was referred by 2 division bench is whether it will be given to the first wife or the second wife of, or both first wife and second wife can get in respect to a person who belongs to the Mohammedan. Because 4 wives is permissible. Now the full bench say that you can't maintain a wreath. The second wife can't maintain a wreath. Yeah. If you are aggrieved, it has mentioned that the second wife has a right to be maintained, and the first wife will receive the amount as a trustee. But the second wife cannot maintain a wreath. For maintenance. And she has to go civil court. Now, if that is being done, just imagine, if this thing would take years. For all other aspects, like you have 125 for the wife, there are this pronoun or whatever, these acts are there for the purpose of the parents and all. These are there, maintenance. But how do you take care of a wife to wife? Or widow to widow? And if he has to go to the civil court, it will take minimum 3 years. Yes, that is the judgment 2022 SCC online GAU 2000. Mr. Chaudhary, I will ask you to assist this court on that because something needs to be done on that aspect. Because sending people out there with due respect to the full bench to the appropriate forum has been creating a lot of problem. Where will they go? Although I have been giving liberty to them for the purpose of approaching the authorities out there, the authorities to do something. But that can't be done if they can't maintain a writ. Absolutely. No, for maintenance. After having held that this is the amount that she would only, the first wife will only receive it as a trustee. Then relegating this person to apportionment there, that is what has been done. They cannot maintain a writ direct for a direction upon the state respondents. This is the words used for apportionment. However, liberty has been given to the state respondents in a given case to consider. That is a problem which is being faced. So what I have done in one case, I passed in where there is a case of area pension of the husband along with DCRG and the family pension. Family pension I have referred, I have no other way because of the full bench. But area pension as well as the DCRG, I said that it is the property of the husband. And as such, by virtue of the personal law, it will devolve equally amongst them. But what to do about the other one? No. So I will request Mr. Chaudhary kindly help this court on that. Something needs to be done because many cases we are having this problem. Yes, you can ask your junior, who is there? The citation is 2022 SCC online GAU 2000. SCC online GAU 2000. Yes, Mr. Bharadwaj. We do one thing. It's a pension matter. We can't make it more complicated. You want the director of pension. And whom do you want? Huh? AG. Okay. We make them party. You give the extra copy. Miss Embora.
Yes, sir.
The learned counsel appearing on behalf of the petitioner. Mr. P. Bharadwaj, the learned counsel appearing on behalf of the respondent number 4. Mr. You are appearing for? No. You are accountant general. Okay. Mr. So and so appears for the respondent number 1, 2, and 3. Upon hearing the learned counsel for the parties, it appears that the that without the director of pension, as well as the office of the accountant, principal accountant general AE, not made parties to the instant proceedings, an appropriate writ cannot be issued in the instant proceedings. Taking into account that this is a pension matter, this court, in the interest of justice, impledes the director of pension having his office at Housefed Complex, Guwahati 781006, as the respondent number 5 to the instant proceedings, and the office of the principal accountant general AE having its office at Moidamgao, Guwahati 29, as the respondent number 6 to the instant proceedings. Mr. S.R. Burwa, as well as Mr. R.K. Talukdar, who are present in the court, duly accepts notice on behalf of the newly impleaded respondent number 5 and 6. The petitioner is directed to serve extra copies of the writ petition during the course of the day upon them, upon the said counsels. The registry shall make necessary correction of the records on the basis of the instant order, and also would reflect the name of Mr. S.R. Burwa appearing on behalf of the newly impleaded respondent number 5, and Mr. R.K. Talukdar appearing on behalf of the respondent number 6. List the matter again on 10th of May 2023. Yes?
16th of
Okay. 15th of May 2023. You'll serve the copies, madam?
Yes, sir.
21,
Yes.
Lordship, in this case, my instruction is Lordship, department needs 3 weeks time, Lordship, to resend the proposal to the Lordship AG Lordship. It is under process, Lordship.
Otherwise, only for 40 issue, my lord, already.
Eh?
Numbers of communications are there, my lord. From 2013 it is, my lord.
Area salary or what?
No, my lord, family pension. my
Family
lord.
pension, Lord.
Yes, only because of the name Nasia Bibi, Pewa
Second
and
one.
Nasiatan Bibi.
We have not received the family pension from
Nothing, not at all.
2013.
Just a single penny.
Huh?
Just a single penny I have not received, my lord.
Just a?
Just a single penny, my lord.
Oh, just a single penny.
my lord.
Okay, we are now in England. Okay. Heard Mr. 8 stars, the learned counsel for the petitioner, Mr. N. Upaidhyay, appears on behalf of the irrigation department, as well as Mr. R.K. Talukdar appears on behalf of the accountant general A.E. SAP. Mr. N. Upaidhyay, the learned counsel appearing on behalf of the petitioner, the irrigation department submits that he requires some accommodation so that the revised pension proposal.
Lordship, in fact, we have sent the pension proposal to the AG. AG has returned with certain queries, Lordship. We have to meet up the queries and
Had submitted, Mr. N. Upaidhyay, the learned counsel appearing on behalf of the irrigation department, has submitted that the family pension proposal of the petitioner was duly sent to the office of the accountant general AE, who has returned it back. And as such, the petitioner, as such, the irrigation department is taking steps for the purpose of submitting the revised pension proposal. It is under such circumstances, Mr. N. Upaidhyay seeks for an accommodation. This court fixes this matter on 10th of May 2023. This court further would like to take note of that the petitioner have not received the family pension since 9/5/2013. A decade have already passed by. A decade is almost to be completed. And it would be a travesty of justice. If no action is taken upon the respondent authorities for the delay in processing the family pension of the petition. Under such circumstances, this court puts the irrigation department into notice as to why interest at the rate of 12% should not be imposed upon the authorities of the irrigation department, upon the Department of Irrigation for delay in finalizing the pension of the petitioner, family pension of the petitioner, from the date of the entitlement of the petitioner. This court further shall consider on the next date as to why such interest, if so imposed, should not be deducted, should not be recovered by the department from the salary of the erring officers.
In fact, there is discrepancy in the name of the petitioner. It is the reason why, Lordship.
I am not concerned. 2013, does it look sense? Does it make any sense from 2013 till now? A person is not working. You do one thing you do in the irrigation department, stop giving pension to people, salary to the people for 1 year before they retire, or reduce it. Then it will look fine. They are not entitled for 10 years.
22.
I am only putting you to notice. But next time, if I don't get a result out there that something has been done, this court will impose interest. Yes, Mr. P.N. Sharma, what instructions you have got?
Lordship, I have received instruction, Lordship. The petitioner here is the second wife.
For this case, the petitioner does not appear.
Lordship.
Yes, what is it?
The petitioner is the second wife, Lordship. And this report has been submitted by the
First wife of
Inspector,
claim the release of pension in her name, the family pension. Petitioner is the second wife.
second wife, Lordship. On the basis of the next of kin certificate obtained by her, she started getting pension. Once the first wife approached the authority and applied about the matter, and thereafter that pension has been.
Is the first wife getting pension?
No, Lordship.
Then?
No, Lordship. That because of this pendency of this matter, Lordship.
Is it so?
Pension preparation, Lordship. Paragraph that clause 5. It is stated, Lordship.
Huh?
Clause 5 of this instruction, Lordship.
The first
Srimati
wife,
so-and-so, so-and-so. Second wife of let so-and-so, so-and-so in between approach the what so-and-so, and the next date. Is the second wife, Lordship.
This is the repetition. And the next week of we dismiss the petition. You give it to the first wife. Mr. Sharma,
Lordship.
you give it to the first wife.
Lordship.
Because as per your instruction, the second wife is not entitled because it's a void marriage.
Lordship, the instruction in clause 3, it is written here.
I've read it.
Lordship.
Read it. You have mentioned it in Roman 5.
Lordship.
I've read. So I'll dismiss the petition. None appears. But you take the step for the purpose of releasing the pension to the first wife.
Lord.
Okay. None appears on behalf of the petitioner on call. It appears on record that the petitioner was not represented on 9/3/2023 as well as on 17/3/2023. Mr. PN Sharma, appearing on behalf of the Departmental of Schools, had submitted a set of instructions given by the Deputy Inspector of Schools. As per the said instructions, it appears that the petitioner herein was the second wife of late Tileswari Isalari. Full stop. On the basis of our next of kin certificates so produced by the petitioner before the respondent authorities, the petitioner had received certain amounts of pensionary benefits from the concerned authority. Subsequently, Srimati Joymoti Salary, the first wife of late Tileswari Salary, had approached the office and then it came to the light of the office of the respondents about that late Tileswari Isulari had a first wife. In that regard, a police case have also been registered being Gopur PS case number 122/2022. It is further mentioned in the said instructions that the petitioner being the second wife which is a void marriage cannot find place in the list of nominee in employees service book. And the second wife is not entitled to the family pension. The instructions so submitted by the learned counsel appearing on behalf of the school education department is kept on record and marked with the letter Y. Taking into account the said instructions, this court dismisses the writ petition as the petitioner herein is the second wife. Full stop. It is further observed that as Srimati Joymati Isilari is the first wife, as per the instructions so submitted, the respondent authorities shall do the needful for the purpose of processing the family pension to her at the earliest.
Okay.
28.
Yeah, in the case, my lord, we need to have filed our rejoinder, my lord. Affidavit has been filed, my lord. And showing that, my lord, there is a different matter, my lord. But what is the instruction, my lord? They have laid the charge sheet, my lord. We received the copy. of notice, my lord, and we have applied the certified copy of all the statement, all the materials, my lord.
Who has filed the affidavit in opposition?
My lord, by the railway authority, my lord.
Then you have got the copy.
Yes, I got that.
Very well. What do you want to do now?
Now, my lord, I have to file rejoinder.
Very well. How much time? 4 weeks, 8 weeks?
No, my lord,
Okay. How much?
3 weeks. Immediately after vacation.
Immediately after.
The date may be given, my lord, first.
Heard Mr. J.L. Balbhuia, the learned counsel, appearing on behalf of the petitioner, Mr. P. Parasar. K.K. Parasar appears on behalf of the CGSC, a central government. It has been brought on record that it has brought to the attention of this court that an affidavit in opposition has been filed by the by the respondent number 1 to 6. The petitioner submits that they would have like to file a reply in that regard, that the matter be listed on 3rd of May. 3rd of May. The petitioner is given the liberty to file any reply if so advised.
32.
Yes,
May I please deduct?
Mr. N. Upadhyay, where is he? Mr. Nayak, what is there?
He was a master employee, lordship, regularized in the year 2005. Initially, lordship, in the regularization order, his date of birth was different. Subsequently, in the service book, lordship, that has been changed. Accordingly, he continued for some more years.
Hmm.
Now, lordship, may please come to is 48 lordship.
What is this division bench judgment?
That is
Not applicable.
not applicable, lordship, but she has already admitted her case.
Okay,
Case
let us
48,
see.
lordship, he has been paid terminal gratuity. Now, for the overstay, lordship, an amount of rupees 11 lakh was to be recovered.
Could not make out how the overpayment from the
So far as recovery is concerned, lordship, I am saying nothing, but it is clearly misrepresentation, lordship. That is one issue. And secondly, pension is concerned. He has not got pension, lordship.
He will not receive pension.
Yes, that judgment applies in that situation.
He's entitled to pension.
Yes. He initially joined in the year 1984, regularized 2005, and going by the regularization order, lordship, he should retire in the 2008. Then also it is more than 20 years. Lordship.
What is your date of birth, madam?
Lordship, may kindly see page 20.
Mr. Nayak, if you are putting allegation of misrepresentation, don't you think that you should put it by way of an affidavit?
Yes,
I'll give you time. When you are the
but
person.
it is out and out misrepresentation. Lordship, will see page 20, lordship.
Respondent number 5 and 6, you are appearing Boroland, BTC.
Yes, sir.
You want to allege misrepresentation.
It is admitting.
Where?
Page 20.
Page 20, affidavit.
Yes, lordship. The age 75 years. Means he should retire. He should have retired in the year 2008 itself.
When did he retire?
Beyond 2008.
15 years before.
Up to 2015, I think.
60, na? Age of retirement? 60.
As for the, yes, at that point of time, it was 58, I think. 2008.
Now 2008 is 59. 2005, it was made 59.
Then he should have retired at the age of 59.
Okay.
Whatever is, as per the regularization order, he should have retired in the year 2008. And petitioner is admitting in his affidavit that his age is 75 years, meaning thereby that his date of birth is 1948.
But
remaining
then
are-
also, I think you should put it by
Lordship, I'll
way,
find out.
2 weeks time is granted,
Some more time.
4 weeks time is granted to the respondent number 5 and 6, represented by Mr. P. Naik, for filing the affidavit. List the matter again after 4 weeks.
Thirty-one.
Without K. Mozumdar is out of.
Huh?
K. Mozumdar out of issues of the Supreme. Kindly fix the date after any date of.
Yes, they have got your instructions. If it goes in your favor, what is the instruction? Yes, which department? Elementary.
Lordship, here my telephone instruction is Lordship, the director has already instructed the DF school, Deputy Inspector of the Schools, Nagaon, to furnish the necessary documents and report on 16th of March, Lordship. And thereafter the DF school has been processing. Now that director is yet to receive that
16th of March.
Lordship. The matter last came up on 17th, Lordship.
Then what happened now?
Thereafter that I'm instructed that the department DI of the school is processing the matter and they will be furnishing it to the director office. So the director office is yet to receive that detailed report.
Give you time till May 17th.
Lordship.
You get your things. Heard, Mr.
A. High.
A. Hawk.
High.
The learned counsel appearing on behalf of the petitioner. A. High. Mr. P. N. Sharma appears on behalf of the Elementary Education Department. Mr. S. K. Medhi appears on behalf of the Accountant General AE, and Mr. S. R. Borwa appears on behalf of the Director of Pension. Mr. S. R. Borwa duly informs this court on the basis of instructions that the papers, pension proposal of the petitioner have been returned to the Deputy Inspector of Schools, Nagaon, for meeting up certain deficiencies found in the pension proposal, but no reply had been received from the Deputy Inspector of Schools, Nagaon. Mr. P. N. Sharma submits, learned counsel, Mr. P. N. Sharma submits that he would instruct his department to take necessary steps at the earliest so that the pension papers of the petitioner could be furnished as early as possible. List the matter again on 17th of May 2023. On which date the learned counsel appearing on behalf of the Elementary Education Department shall apprise Elementary Education Department as well as the learned counsel appearing for the Pension Department shall apprise this court as to whether the revised proposal have already been submitted by the Elementary Education Department to the Pension Department. The instructions produced by Mr. S. R. Borwa is kept on record and marked with the letter X.
I don't, in this last page, exercise 16 page 63, my lord, there's a letter from the block elementary officer, my lord. There's written, my lord, the accountant manager AE, my lord, Beltola, my lord. My lord, this relating to GPF, my lord. My lord, this such accountant manager, my lord, Beltola, there is no such accountant manager. So whether this so far relating to GPF, my lord, last page.
Let us first deal with the pension.
GPF also.
33.
Lordship, in the last occasion, Director of Pension was impleaded in this case. Lordship, I need some further time, Lordship.
Mr. S.R. Borua, learned counsel appearing on behalf of,
Person of 5.
wait. Ah. Have you paid the provisional? You've got it
No.
till now?
Well,
What is this?
There's,
Which
early
department?
allocation, they want
Madam, which
some time.
department? Provisional pension, you need to do it.
Second.
Why did nothing has been done? And this order is a detailed order. 111119, Mr.
21/9/2021, while closing the earlier contempt proceeding.
I've seen it. It's a long order. Have you seen my order of 10/3/2023?
Malo.
Then I don't understand.
They, Mr. Borua sought time on that day.
Then?
Definitely.
Why this is happening?
I think your provisional pension already sanctioned. That's the instruction that I have received. Provisional pension has already been sanctioned.
Okay.
On
I do one thing.
8/11.
We'll fix it on 26th of April. Get your instruction, both of you. And in terms of the order dated 10/3/2023. Okay. Mr. Goswami, the learned counsel, UK Goswami, the learned counsel appearing on behalf of the petitioner. Ms. D. Musari appears on behalf of the respondent number 1, 3, and 4. And Mr. S.R. Borua appears for the respondent number 5. This court, by the detailed order dated 10/3/2023, as well as 17/3/2023, have sought for certain instructions. It has been mentioned by Ms. D. Musari that the petitioner is presently receiving the family, the provisional pension. However, the instructions so sought for has not come. Taking into account the say, let the matter be listed on April 26th of April 2023, on which date the learned counsel appearing on behalf of the respondent shall apprise this court in terms with the order dated 10/3/2023 and 17/3/2023.
37.
May it please allow.
Yes.
Well, this matter, it's a matter pertaining to suspension matter. Lordship will
Oh,
kindly.
that thing, that pattern
Yes, sir.
on 17th of
Yes,
March, you
Yes.
have issued that,
yes.
the memorandum.
There,
Yes.
my lord will kindly take note of few dates, my lord. That
Ah.
will make the position clear.
Hmm.
10/11/22 petitioner was arrested.
Hmm.
12/11/22 petitioner suspended. 14/11/22 petitioner was granted bail by this honorable court.
Hmm.
12/12/22 petitioner communicated the bail order. They say they received it on 17/12.
Hmm.
Then my lord, 18/2/23 review was done. Then 17/3/23 they say they have issued the show cause notice on oath. That's not correct. Show cause notice was issued on my lord 23rd, and we received on 6th. My lord, today we have filed an affidavit, my lord, where we have brought on record the track record, my lord.
Hmm.
Yes.
If lordships would kindly come to my lord, page number 88, 89. In fact, my lord, that page 88 is the envelope. And you see, my lord, on the right hand side, SPA 2000, date of dispatch 22/3/23.
23.
Yes.
23.
23. And it was received by us on 6/4. And kindly come to the track record, my lord, at page 89. Kindly see, my lord, starting from just bottom, my lord, 23/3/23 item book. Then 23/3 item back. And eventually, my lord, on first 6/4/23 out for delivery. They must have thought, my lord, if we can show 17, we can overcome that 90 days period. Now, here in this case, my lord, even from 17/12/22, when they say they received it, my lord, then, my lord, the show cause notice was not issued within 90 days or 3 months. Days or 90 days will come to an end on 16/3/23. Even taking note of the
Why
fact
was the
that February.
petitioner arrested in this case? Under
My lord?
7? Why was the petitioner arrested?
My lord, what had happened? There was an incident of, my lord. Actually, it was a case of rape. Huh?
Rape and murder.
Rape and murder, or as a case under POSCO, my lord. Petitioner was a very fresh executive magistrate, my lord.
Huh.
Not executive magistrate, they call it a revenue officer, my lord. Circle officer. My lord, he did the inquest report, my lord. And my lord, we made a statement in the writ petition where we challenged the, my lord, bail application, sorry, in the bail application. They were never trained, my lord. Actually, my lord, they were not executive magistrate. They were, my lord, that Assam Revenue Service officer. So there was some flaw in the inquest report, my lord. That we are not disputing. That is the only part I'm involved.
Where is the, you have not included the show cause? Yes.
Yes, no, they have brought on record, my lord, by filing affidavit.
Case 54 also. Running case.
What are the charges against him?
Yes. Case 54. Paragraph.
Page 54, madam. The allegation is of not performing duty, my lord, to the best of his ability.
You have submitted your reply.
No, my lord. No. We have got it only on 6th, my lord.
Hmm?
My lord, on 6/4, we have received the copy, my lord. And today we have applied for inspection of the document. 6/4, we received the so-called by post. Here, basically, my lord, we have challenged the suspension order.
Only on Ajay Chaudhary,
Yes, my lord.
no other ground.
No other ground. Even counting from 17/12, my lord, 3 months will be over by 16/3. My lord, these aspects were not there when the writ petition was filed. These are all subsequent developments, filing of charge sheet and all. Now, they should not have made that statement that they have dispersed it on 17/9. On oath, they have made that statement.
It may have been from their office, it may have been sent. If you
No, my
see
lord.
this,
No.
you kindly see this.
No, my lord, if it is lying in the office of the, office, that will not do, my lord. There is no dispute that it was dispersed on 23rd. And the envelope is also very clear, my lord.
That is what I am seeing from the envelope only, I am saying.
Yes.
That there is a noting to that effect that
No,
on
my lord, this can be
17th,
done, my lord. 17th
confidential by speed post out
Yes.
today, but it was posted on
My lord, I can
22/3.
appreciate 17 being a Friday. If it would have been, dispersed on Monday also, I could have. 17/3 is a Friday.
Hmm.
So we can, if it is a second Saturday.
They've done it on Wednesday.
They have done it on Wednesday.
And this court fixed the matter on a particular date when he said that we have
It was
already
fixed
done
on 17, my lord.
on 24th.
24th.
This court had fixed the matter on 24th. On
Once it
that
was fixed
day,
on
it-
17th, my lord.
Huh?
Once it was fixed on 17th.
But what do you say about paragraph 22 of the Ajay Chaudhary judgment?
No, paragraph 22, my lord.
Hmm.
That was in the facts of that case.
Hmm.
Paragraph 22 is regarding the facts of that case.
Yeah.
Appellant has now been served with the charge sheet and therefore these directions may not be relevant to him any longer. However, the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action of the respondent will subject to judicial review. Well, the fact that I have been put on continued suspension, that itself is a punishment. My suspension is never intended to be, a punishment. But if it takes the color of punishment, then what happens?
Now, if it takes the color of punishment, obviously this court can
Yes.
interfere with.
Yes.
But can you apply 22, paragraph 21 without looking into 22?
No, para 22, my lord, it says now, therefore, direction.
This person was not given the charge sheet
Benefit of
for a
the order.
long time.
Yeah.
Then also the court would have very well said that we are set aside that, but why didn't the court didn't do it?
Here, my lord, if your lordship would kindly come to paragraph 11 for a moment, my lord.
Of Ajay
Ajay
Chaudhary?
Chaudhary, yes.
Yes, that is the thing where it has been mentioned that it will be punitive.
Hmm.
Long period of year would be punitive. I remember that.
It says, my lord, suspension, especially preceding the formulation of charge, is essentially a transitory or temporary in nature and must perforce be of a short duration. If it is for an intermediate period or if its renewal is not based on sound reasoning contemporaneously available on record, this would render it punitive in nature.
departmental disciplinary proceedings invariably render it punitive in nature.
Mr. Chaudhary, what about making an argument to the effect that what is the reason of suspending?
The reason of suspension is, my lord, yes, I was about to come to that. The reason of suspension is, my lord, so that I do not tinker with the.
That's all. If that is so, why is it
Where is the
necessary?
scope?
Or is it that you want to suspend him as a punishment?
I should not be in a position to.
It shouldn't be
influence
a
the proceedings.
punishment, but you can suspend him for whatever may be. The reasons are there. You can very well do it for it, but it shouldn't be a form of a punishment. Is it for the fact that you want to suspend him for punishment? Have you mentioned why do you want him to be suspended? Yes, he has said about Ajay Chaudhary. That's one under the aspect of the matter. Ajay Chaudhary 22 may take care of your health. But why is it necessary for his continued? Because you have to give a reasoned order when you extend. Reasoned order has to be, is it for the purpose of departmental proceedings? Merely because you are holding a departmental proceedings cannot be a reason for that. That has to be on the basis of, there has to be a reason that if he remains out there, he has the opportunity to think with the evidence.
Already, suspension order has been extended.
Huh?
Right order is 18 to
Yes,
23.
why? Why have you extended it? Isn't that the second part says, Mr. Chaudhary, the
Yes, my
second
lord.
portion
My lord.
says, the second portion of that order, paragraph number 21 says the currency of a suspension order should not be more than 3 months if
yes.
the memorandum is not there.
Ah.
But if you are going to extend it, if the memorandum is there, then also you have to do it
Give a
with a
reason.
reasoned order.
Yes.
What is this reason behind it?
That this has been given, Lordship, 18 to 2023.
Huh?
Exception is 35.
Of
Writ petition.
the affidavit
No, Lordship, writ petition.
of the writ petition?
Yes.
No, my lord, the page 35, they've given, the order is there, my lord.
Yes.
Okay.
Yes.
Why have you extended it?
Considering the seriousness of the matter.
Whereas considering the seriousness of the matter.
No, no,
the
he,
government
Mr. Doctor, he is not, that is why I asked him, what is the offense? He is not under, he is not the person who committed 376 or 302 of POSCO. Is he there? That is not the case. The case is of dereliction of the.
Yes, being a responsible officer,
Absolutely.
he should have.
But are you saying that because being a responsible officer, you are suspending him as a punishment?
No, not
Then
at all,
why you are
not at all.
suspending him? Mr. Chaudhary, I'm hearing another suspension matter of yours on
Yes.
21st or 27th. Another suspension matter, which I have picked. Well,
Yes, yes.
we'll take it along with that.
Prasanto Datta.
When we are fixing it, that is also revenue.
20, my lord.
Huh?
20.
No, revenue.
That is on 20.
Police officer.
Police officer.
20, na? We'll have this on 20.
20, my lord.
Huh? Because today is pretty long.
My lord.
24.
You just think about it, Mr. You see, why do you need his suspension? The grave or the grave serious matter is a matter pertaining to the offense. Very well. Unless you say something to the effect that he may tinker with his evidence or do something to that effect,
Or
which he
influence the
can't.
proceedings.
Should we not take it in the same perspective of a bail?
Yes.
Would he be in any position to tamper with the evidence if you allow him or post him some other place?
Yes.
So the reason order has to be on the basis thereof. Think about it. But Mr. I hope I'm sitting next after vacation. I'm fixing all these matters. But Mr. Ken Chaudhary, the senior counsel assisted by Mr. J. Patwar and Mr. S. Datta, the learned counsel appearing on behalf of the respondent. On hearing the matter and perusing the documents, this court fixes the matter again on 24/2023, 20, huh? For further consideration.
39,
Yes.
May please. My lord, by order 24-3, your lordship directed my lord the government advocate to produce the record. Whether the charge sheet, my lord,
I
has
have
been,
not asked them to produce record, have I?
my lord.
I'll say the here the learning appearing on behalf shall apprise the court on the next returnable date as to whether the memorandum of charge sheet has been served upon the petitioner. Shall also produce such memorandum of charge, if any. Further to that, the learned counsel on behalf of shall also obtain instruction as to whether there has been compliance to the judgment of the Supreme Court rendered in the case of the.
Lordship.
Yes.
Regarding the arrest of the person came to the knowledge of the Deputy Commissioner's office, Lordship, when the arresting authority sent a proposal for sanction. On that date, Lordship, it has come to their knowledge on 13, though the person was arrested in the month of August, on the month of August, Lordship, but that knowledge has come to the notice of the Deputy Commissioner's office on 13/10/2022. Accordingly, Lordship, thereafter, the person was put under suspension. I'd order dated 29 October 2022, as because he was put behind the bar for 3 days. So accordingly, Lordship, he was suspended. Thereafter, Lordship, the so-called notice was issued to him. I'd later dated 30th of November 2022, along with the statement of allegations. No reply from the side of the delinquent officer.
I have stated-
Thereafter, Lordship, I'd order dated 18th of March 2023, departmental proceeding is directed to be initiated against the delinquent officer. If your Lordship wants to,
You
may I?
have issued departmental proceedings. And when did you issue the SOCOS then?
SOCOS, yes, SOCOS was issued.
Statement of allegations was,
Yes.
isn't that a part of the inquiry?
Yes,
9-2.
as because he has not submitted any reply.
So the departmental proceedings have started before that.
No,
How can it be?
Lordship may kindly come to the page number 5. Page number 5, I have marked it with pencil, Lordship. That is the order of suspension.
So forth. In case you have intent to.
Then next page, page 6 is the so-called notice along with the statement of allegation. And he was directed to submit his explanation in defense within 7 days. Which he did not comply.
Has he received that SOCOS?
It was sent through post.
Then where's your post?
And if your lordships come to page 9, it seems that he has received that letter.
Why?
He has made a prayer enclosing, claiming for certain documents. That is at page 9. That pencil marking. This is a prayer petition. Enclosed, please find here a copy of the letter number so and so dated so and so 1/2/2023. 1/2, that is the at page 8. He is asking for 2 documents. One is dated 1/2/2023 and another one is 13/10/2022.
Where?
Your lordships come to page 9.
Page 9, that is what I am saying.
If your lordship enclosed, this is addressed to the delinquent officer.
How do you say that he has written it?
Yes, lordship.
Where is it mentioned?
Enclosed, please find here the copy of the letter number so and so 1/2/2023. 1/2/2023 is page 8.
1, 2, 3.
Page 8.
Lordship will mark that is an order against me. No copy has been served to me, madam.
That is what I am inquiring.
Copy has been marked to the government advocate, but not to the delinquent against whom
That
this
is
order
why
has
this
been
prayer
passed.
application.
And therefore, it required to, my lord, file the my lord, subsequent application on 6th March, pursuant to which, my lord, 55 sheets have been, my lord, given to me.
Yes.
And this 55 sheet does not contain, my lord, charge memo, show cause, nothing. I have with me this one, 55 sheets. Absolutely
Yes,
nothing.
Lordship, that 55 seats relates to that
Can
proposal
you show
for,
me your prayer petition?
My lord,
Show me your prayer petition for which the 55 pages have been given to you.
my lord, this has been numbered by them. This is from-
Understood, understood.
Yes,
These 55 pages have been given to you. Why?
because, my lord,
You
why-
must have made a prayer petition.
Yes, I made a prayer petition.
Where is it?
As per page 35, your lordship, I have pointed out to your lordship that, my lord, this order was not served to me.
Page
35
35.
of the, my lord, my
This is the
petition.
prayer petition. Where is
No,
your prayer
this is
petition?
not a prayer petition. My lord, since, my lord, this order was not served to me.
No,
so
no.
I
How did
plead-
you? No, Mr. Talukdar. How
I
did you
understand,
get?
but that copy is
Why
not-
did you? What? Can you show me the documents of 1/2/2023 and 13/10/2022?
1 to 2023.
Can you show me the prayer petition
the
which
prayer
you have given?
That copy is not retained by the petition.
Why?
It ought to have been written.
That is the main document.
Yes,
You have it?
it is part of
no,
the
Lordship.
No, definitely you will have.
No, no.
Otherwise, why you are
Yes,
replying on
Lordship,
the
but
with
that,
the
that
big
petition,
bolded
it
with
was not
bold
sent to
letters?
me, Lordship.
You are putting a prayer petition.
Yes.
Then
That is why, Lordship, I am saying that these two documents he had not received, accordingly he prayed. So it was sent to him, the so-called search sheet. He has not make any prayer for that, Lordship.
no, he has not received this one.
Yes.
Then 1310 is what?
1310 is that proposal for sanction, Lordship. Prosecution
Sanction.
sanction.
But has he received this particular document? The show cause notice?
No, madam, no,
1310,
3011.
3011.
Yes. But it was sent through post.
Then you have to show us
Yes, yes.
whether he has been served.
I will try to bring that prayer application along with this, any document regarding.
Yes, do have. Because these documents
Yes,
otherwise
Lordship.
it's not.
These two document, Lordship, I will try to bring out.
We'll fix it on 19.
19 will be too early, Lordship.
Okay, 12th. Suspension matter.
Lordship.
Every day suspension is important.
No, Lordship, that is true, but on 19, Lordship, 19.
I want only those documents.
Lordship,
And you are at liberty to file your affidavit and bring on record, because if you are making allegation against him that you have served, put it on your affidavit. We'll have it on 21st. File your affidavit by 2019.
Lordship,
You have to put it on affidavit. We can't say that you can't just say that we have given it to him. Put it on affidavit, you have served it to him.
No, Lordship, that instruction we have received, that it was sent to him through post. Whether it is received or not, if it is sent through the registered post, that receipt must have been with us. And regarding the prayer application, that should also be with us. That these two documents are
No,
not
not
with us,
only
Lordship.
that.
Now at this stage.
Now tell me one thing.
Lordship.
See the last document at page number 10.
Lordship.
This is an order being passed by the Deputy Commissioner and the Disciplinary Authority.
Lordship.
You have appointed a presenting officer as well as the inquiry officer.
Lordship.
When do you appoint a presenting officer? Or the inquiry officer? After he delivers his defense. What are you
No,
going to
Lordship,
inquire?
as because he has not submitted any reply. So had he submitted any reply, Lordship, being not satisfied, in that case, departmental inquiry will proceed. So as because he has not submitted any reply, that is why, Lordship, this departmental proceeding was initiated.
Departmental proceedings, Mr. Sharma, does not initiate on the basis of that. Departmental proceeding initiates on the basis of 9(2).
Yes.
That is the show cause.
So cause.
With
So cause
definitive
was,
charges.
yes,
So departmental proceedings have already initiated.
initiated.
This is only an appointment of an inquiry officer and the
Lordship,
presenting officer.
Lordship. Lordship, from the date of that that so-called lordship, the departmental proceeding has
Have
already
been
Yes.
initiated. Then, Mr. I'm not giving all these things. here.
Lordship.
Mr. S.K. Talukdar, the learned counsel appearing on behalf of the petitioner. Mr. S. Datta appears on behalf of the respondent number 1 and 2. And Mr. H. Sharma appears on behalf of the respondent number 3 and 4. The learned counsel appearing, Mr. H. Sharma appearing on behalf of the respondents number 3 and 4 submits that there was a memorandum of charge which have been issued in the month of November 2022. And the petitioner, in pursuance to the said memorandum of charges, have not submitted the reply. And pursuant thereto, in terms with Rule 9.4 and Rule 9.5 of the Assam Discipline and Appeal Rules 1964, the disciplinary authority have already appointed the inquiry officer as well as the presenting officer. On the other hand, Mr. S.K. Talukdar submits on the instructions that the petitioner have not received any memorandum of charge till date. Taking into account the said statement made by Mr. S.K. Talukdar, the respondent, more particularly respondent number 3 and 4, are directed to file an affidavit as to when the memorandum indicate bringing on record the necessary documents, as well as also indicating therein as to when the memorandum of charge was served upon the petitioner. List on, no, the said affidavit has to be filed by 19th of April 2023. List the matter on 21st of April 2023. Liberty was given to the petitioner for mention the matter for. Oh, that Rajiv judgment, Mr. Talukdar, you look.
Yes, I have got. Yes.
Lordship,
Your first argument.
Yes, that is contrary.
from 13 to 18, Lordship, there is a holiday, Lordship. May pay Lordship 2-3 more days.
A person is under suspension.
Lordship, undoubtedly, but he is
Mr.
getting 75%.
Sharma, kindly take note. What is the?
No, he is getting 75%, Lord. 3 months have already done by Lord. One night. That day, I'm only praying.
You have Ajay Chaudhary's judgment?
Well,
just read paragraph 12.
No, Lordship, that is there, Lordship, but
no, that is most important. Paragraph 12.
No, Lordship. No, Lordship is there, but because it's holiday, I'm only praying for 2-3 more days time, Lordship.
Repeated renewal thereof have regrettably become the norm and not the exception that they ought to be. The suspended person suffering the ignominy of insinuations, that is scorn of society and the derision of his department, has to endure his excruciation even before he is formally charged with some misdemeanor, indiscretion, or offense. His torment is his knowledge that if and when charged, it will inexorably take an inordinate time for the inquisition or inquiry to come to its culmination, that is, to determine his innocence or iniquity. Much too often, this has now become an accompaniment to retirement. Indubitably, the sophist will nimbly counter that our constitution does not explicitly guarantee either the right to a speedy trial, even to the incarcerated, or assume the presumption of innocence to the accused. But we must remember that both these factors are legal grounds, norms, are inextricably tenets of common law jurisprudence, antedating even the Magna Carta of 1215, which assures that we will sell to no man, we will not deny or defer to any man either justice or right. In similar vein, the 6th Amendment to the Constitution of the United States of America guarantees that
Enough,
in all
Mr.
criminal
Talukdar.
prosecution.
Don't now put him to the amendment of the 6th Amendment to the Constitution. But he had, really? 40, the Supreme Court has categorically mentioned. So it is not be. If it was, I was sitting in during the vacation, I would have put this matter before that. But I'm not sitting.
Obliged.
Yes. Where is the Mr.? Yes,
That is on page 37.
you don't have a case. You don't have a case.
I was relieved on the charge of attachment, my lord, on the basis of my lord proposal submitted by the CDPO.
Whenever there is a transfer order, you are before this court. Tell me,
I am in.
you have got all the stay and all their petitions have been dismissed. Your only question is that why on 17, after the order on 15.3, why on 17 it was again changed? Isn't that the case?
Lordship, I was in Algapur, my lord, 2 years, 8 months, 1 day, my lord. From last 2 years, 8 months, 1 day, my lord, I was in Algapur. ICTS program on attachment. On the basis of recommendation, my lord, I was relieved from the charge of. Kindly see the, my lord, Annex 12, my lord. Order is itself reflected, my lord. Kindly see, my lord, 37 page. Annex
Which one?
12, my lord. Annex
Order
12.
dated?
Annex 12, my lord.
Order dated?
Lordship, on the basis of recommended.
Mr. Counsel, order dated.
Order dated, my lord, 15 March 2000.
I've seen it. 15 March,
Yes,
you have been brought to Lala
yes, ma'am.
from Algapur.
Yes.
Algapur was given to Kanu Das,
Yes.
isn't it? Then, but what were you doing all this while?
Lordship,
After the judgment of Justice Michael Jothankumar, what happened?
I was in Algapur, my lord.
After the judgment of Justice Monojit Bhuiya, what happened?
Lordship, I was in Algapur last 2 years, 8 months, 1 day.
Last 3 years, where were you? In 2012,
Yes, ma'am.
you were in Kalen,
Yes, ma'am.
you were brought to Lala.
Yes, ma'am.
Okay.
Yes.
Then from Lala in 2014 or 16, you have been brought to 19.
Yes, ma'am.
You were brought out there to this Kalen. You challenged it first with petition.
Yes, ma'am.
Then you have been brought again out there to given the additional charge at Algapur. You
I
challenged
have
it.
joined, my lord.
Gotta stay there.
Yes, my lord.
And
Stay
after
there, but
this,
I have joined, my lord.
understood you joined. You gotta stay there.
Yes.
And after getting a stay there, in both the matters you gotta stay.
Yes.
Then both the writ petitions were dismissed.
Yes.
However, a consideration was made that let it be considered. That was given in the year 2020. In 2023, then you were removed. You were given now, instead of in Algapur, you are now in Lala. Then after 2 days, this was again removed. Was there any hesitation when you joined, when you were in Lala?
Now, my lord, I am in hanging position, my lord. Where I
You're
am
not
sitting.
hanging. You want the clarification?
Yes, my lord.
Okay, I give you a clarification that you will be joining out there in 17 in Lala.
Lordship, I joined in Lala, my lord, on 16.
You will be there in
16
ICDS
my lord.
Algapur.
Yes, Lord.
You want that clarification? That you will be there in ICDS Algapur?
From
No. Your problem is only that you are in hanging. I make it clear that you will be there in Algapur. What do you say?
I have lordship already joined in.
You are not joined. You joined on 16 immediately. The order was come on 17.
And very next day, my lord, without any reason, my lord.
Reason? Was there any reason for your 15th?
Lordship, statistical assistant is a merely clerical.
Your name
things, my
is?
lord.
What is your name?
HL lordship. The clerical.
All my matters I have taken. There are only 3 matters where I considered giving a stay. 2 matters were there, which has been disposed of. Your matter is the only hanging. transfer.
Statistical assistant.
You
is
first
like
give me a
license-
file and affidavit. What did you do from 2020 till 2023? Where were you? Till 15/3/2023, where were you? Did you submit? Have you seen my first order?
Yes, ma'am.
Did you submit the order passed by Justice Michael Jothankum to the authorities for consideration of your case? No. I
Madam,
think this would help you then.
I was submitted a representation, my lord,
Understood. That representation is of 2019.
2022, my. Another representation. my
That is
lord.
not on record,
Yes, ma'am,
2022.
record, my lord.
Where?
Lordship, Annexer 10, my lord.
Annexer?
Annexer 10, page 30, my.
Page?
Page 30.
P0. Ah. This you have given.
Yes, my.
You want it only in Lala.
Lordship,
Why?
My mother is old age.
She's
somebody
from
old
Lala.
age.
But you were early in Kalyan.
Last 2 years, 8 months, I was in.
You were all along in Algapur only. We'll have it after vacation. Don't worry. Nothing is going.
Lordship status.
Has he joined in this place in Algapur?
Because
No,
there
my
is
lord,
no,
I have already joined in Lala.
But that order has been removed.
Yes.
Now that person is again given the charge.
Yes.
Then how are you joining? Did he give you the charge back? No.
No, my lord.
We'll clarify. You continue to be there in Algapur ICDS. You want that? Or you want to be remaining hanging? Because the problem will be there. This period later on when you retire, I may not be here. By the time you retire, this period of suspension, this period will be a big problem for your pension. What do you want to do? We'll have it after vacation. And you get a better copy of this. I am not going to take up
Lordship,
on this
Lordship,
WhatsApp note.
Lordship.
My goodness.
Today morning, Lordship, we have.
Does it mean that if
No,
this
no, no,
court
Lordship,
gives
and
you a
because-
particular prayer to give
No,
me
no,
on
no.
electronic, does it mean that you
No,
give
no,
it in
no,
this
but,
manner?
It should
This
not have been
needs to
given
be
to your
put
Lordship.
out there in,
No, no, Lordship,
I'm in
I
live
extremely sorry,
streaming.
Lordship.
See the photo of that person concerned.
Lordship, no, it is a today morning, Lordship, somehow.
So, whatever may be,
this copy should not have
particular-
been
who is
given to
this
your
fellow?
Lordship.
CGPO Lala. I think this person needs to come before this court.
No, Lordship,
Or the Gautam Majumdar, who is he? Is he
no,
a
Lordship,
joint
it was
secretary?
sent to me,
We
us,
call him-
Lordship. The copy, Lordship, wrongly was
No,
given
this
to your
is
Lordship.
this the manner
No,
you
no,
have given
I am
in the
extremely
court.
sorry, Lordship, the copy was wrongly
Yeah.
given. Copy was wrongly given to your Lordship.
What is his name? Gautam Majumdar. See, he's not
No,
done.
it is a letter written to the Gautam Majumdar. Just I have been that because of this.
Can't he write a letter?
No, Lordship, morning, Lordship, through WhatsApp, Lordship. It was.
This matter has been pending since when? 31/3. We are today on 10. None of the official, none of the lawyers for the respondents have done this thing.
Lordship, only next day, Lordship will bring it out.
We'll have it on 12. Bring a proper letter.
Lordship.
List the matter again on 12. 12/4/2022.
Lordship.
To be taken up at 2 p.m.
No, sir.
Get your instruction
Lordship.
on which date the learned counsel appearing on behalf of the respondent shall obtain the instruction. Matter who will? Those upgraded matters are
Much of it.
44.
yes. Oh, that matter. I remember. What has happened? Anything?
My lord, by order letter 22/3, State Bank has been impleaded, and on your by the direction of this honorable court, I have obtained instruction.
Ah.
They have
in response to my letter dated 22/3,
Ah.
they have asked, whereby we have asked that fresh sanction has to be given. Fresh sanction was sought for by the State Bank
From whom?
from the Treasury Officer Nogam.
Yes, no go.
In response to my lord, in response to that, they have sought now.
What have you done, Mr. Solia?
Lordship, we
I've
had
directed you
written
in the
to SBI.
meantime, direct the Director of Pension as well as Treasury Officer Nogam to take such steps as necessary so that the petitioner gets a family pension at the earliest.
In this regard, we have written to the SBI branch, my lords. We have asked for the PPO, my lords.
Yes.
But the PPO pension papers have not been forwarded to the Treasury officer.
My lord, that has been dispatched on by the speed post on 7/4, and this is the letter. This is, they have also asked for last payment certificate.
Treasury Office Nogam, you are Roha?
Yes,
Nogam.
Lordship, yes.
And you are Roha.
District is Nogam.
You are State
I'm
Bank
State
Roha.
Bank Roha, where the pension holder is having his account.
Lordship, I have asked the treasury officer. They have not received any documents till date. I only got the
It has only been dispatched on 7/4 to my information. my
7th,
lord.
my lord. Today's 10th, my lord. So we have not received it.
I think these people should make a movie on what you three have been doing.
No, my lord, it is not on
This is
our.
a
Since, my
pure
lord,
simple case of a movie.
my lord, I agree that this is a long pending matter, but
No. First of all, she has not got her pension because of the fault she had been all along applying out there. It has been the fault of the respondent authorities. First comes the elementary. Elementary says that I have nothing to do. Then comes the pension. Pension says that we have made the PPO. We have nothing to do. Then PPO says that both elementary and pension says that look here, it is the treasury who has to do.
Yes, my
Then
lord.
I make the treasury a party. Treasury says that I have duly informed the State Bank. The State Bank should do it. The
They have
State Bank
approached the
comes
State
up and
Bank
says
only,
that,
and
look here, 5 years have already gone by in the process of the interdepartmental communications between the three departments. And as such, we are not in a position we cannot do. Who should pay the interest? I'm disposing of the matter today, imposing interest upon the director of pension, 50%, 30%, 30 on the treasury officer in Roha, and 30 upon the State Bank,
no, my lord,
Lordship,
State,
the
my
branch
lord,
manager of State Bank.
my lord, State Bank
Whose
is no role, my
salary
lord.
from
Since
their
it is more than
salary
1 year.
will go.
Elapse- There is a lapse of more than 1 year, so fresh sanction has to become. They have only written to
Understood.
us. They have
But
never
why this has
approached before the
happened?
treasury officer.
No,
my lord.
no. When the PPO was there, her name was there. Why this
No,
has
it's-
happened? You should have already done it.
Why-
Was her name not there initially in the
Initially, my
PPO?
lord, there was some mistake in her name, in the name of the petitioner, but the wife of the deceased pension holder, my lord.
Lordship,
No,
one
there is
submission-
nothing to that effect.
My lord,
Lordship,
we
one
have,
submission I'd like to make.
There
Lordship.
is no mistake or nothing to that effect.
Lordship,
It
the
is not
conduct
the
of the
pension
petition-
which has got. There's no mistake, madam. There's no, nothing.
My
That
lord-
is another case.
no, my lord, in this case only.
No.
Initially, there, to my information, to my instruction, my lord, there was a
No,
mistake in
that
the
is
name of the
another
petitioner
case.
in the,
That is
PPO
M.
book.
Devi, M. Roy, that is another matter. If I remember that matter.
in this
I'm
case,
not-
my lord, we have been instructed, we have been impeded on 22, and as soon as we got the instruction from this court, I have written
You
down.
are under a duty.
Yes, my lord, I'm not denying that. As on 7/4 itself.
You see, it is not the problem with the State Bank. The State Bank will pay the interest and recover from the salary of the branch manager
No, my lord,
every month
my lord.
if it is too much. You want it in
After a lapse
installments?
of more than, my lord, kindly appreciate after if the
I
pension,
don't know anything.
if it is more than 1 year, my lord, if it
No,
is 11, then the
Mr. Jala-
fresh sanction order
No,
has to
Mr.
be
Jalan,
obtained, my
nothing
lord.
doing.
They have
I am
approached
going
before the
to
bank
impose
after 1 year,
interest.
my lord.
Your will be on the treasury officer,
Lordship.
50%,
Lordship,
and 50% from the commissioner and secretary to the government of Assam Finance Department.
Lordship here.
Both are
Lordship,
responsible.
can I make one submission, Lordship?
No,
Lordship,
nothing doing.
Lordship, the conduct of the petitioner has to be also highlighted, my lords, because the petitioner never approached neither the treasury officer, neither the bank,
Yes.
neither the director of pension, my lords. On whose instruction the petitioner has, the petitioner has never approached any of the authorities, my lords. They have come directly to court. The petitioner has only met the treasury officer 3 days back, my lords. And the treasury officer has directed and given all the necessary
No,
information.
no. First and foremost, when the PPO has already been done.
It was
No,
in the
that
name
is
of
with
the
the bank.
husband.
Wait. when the PPO was already there.
Yes, Lord.
Where is the question of the petitioner going?
No, no, Lordship, the
Now, over India, the question is that to make the
No.
most convenient thing
No,
so that the pensioners are not disturbed out there. And now you're making all this thing that old lady has to go and keep visiting all these offices.
Lordship, the husband
Mr.
of the
Solia, have you been visiting these offices out there? Is it so easy
No,
to
Lordship,
get an appointment out there to the
Lordship,
office?
Lordship, I'm just trying to highlight one point, my lords. The husband was receiving it, my lords. After the death of
That
the
is the reason why when the husband was receiving it, when the wife's name was there, why not the wife has got the pension?
because Lordship,
That is the fault, absolutely the fault of the treasury
Lordship,
officer.
the treasury officer was not even aware, Lordship, of what.
Not necessary.
Lordship, if the
If
deceased.
nothing is happening, the entire chain of the people will have to get it,
Lordship, the
starting from the
petitioner was not-
director of pension, you and them.
Lordship, the treasury officer was not even aware if whether or not the petitioner was getting the pension or not, my lords. Without approaching the treasury officer, without the knowledge of the treasury officer, my lords.
Nothing doing.
Lordship, and neither the Lordship will see the conduct of the treasury. If they have delayed anything, they are not the disbursing authority, my lords. They were only supposed to give the pension.
Last time also on 22/3/2023, I passed that same order
Lordship.
for you to do the needful along with them.
Yes, Lordship.
Yes, ma'am. We have
Didn't you
done our
contact,
part,
have you
Lord.
contacted them?
Yes, Lordship, we
No,
have.
no,
written a-
have you contacted the SBI?
Yes, Lordship, we have written a letter, Lordship.
Then what happened?
Lordship, now they have dispatched the PPO on 7th of April, this
Seven
month.
four on 31st,
They-
in reply to our letter dated 22/3, they have not responded. So we have again reminded them by handing over the paper in person in their office.
And he
Third-
says
on
that he has not
31/3, there is a
received.
receipt. Kindly see page number 2, my lord,
Lordship may show.
of my paper. Down below, 31/3 is written. That is the handwritten copy,
31/3, Lordship.
handed over on 31/3. Since they have not responded to our letter dated
State
22/3,
of health,
page number 2, my lord,
page number 2.
page number 2 down below.
Um,
That there is a seal of the treasury officer Nogam, date is 31/3/2023.
where?
Page number 2 down below, my lord.
Copy to information Padma Kanti Das. That one?
Page number 1, sorry, my lord, page number 1. Page number
With
1.
reference to the family proposal is returned for a pension disbursement for the following. After sanction letter from the pensioning authority is required to claim family pension after a lapse of 3 years. Kindly arrange for the same for processing of the family pension at your end. This was given on 22/3.
22. Since they have not responded, we have handed
Lordship,
over by,
who have they-
please let me complete
Who have you addressed it to?
to the
the
branch, to the
Treasury
Nogam
officer
treasury
Nogam.
officer.
Lordship,
Let me complete. Now, in response to that, my lord, the treasury officer again written a letter dated 31/3, page number 2,
Lordship,
I have the honor to state.
Page
that
number 2,
kindly return
whereby they have asked made a prayer for return the disbursers portion of PPO, which is maintained by the Central Pension Processing Center at Guwahati of the Northeast Circle of the State Bank, my lord, at the central level. And the SBI Roha branch has immediately written on 31/3. And in response to 31/3, there is an exchange of communication by email also it was sent. Page 4 is the communication by where it was intimated to us to the Roha branch that by the speed post the same has been dispatched. Yes, my lord.
Then
Then is on there is a on 7/4 itself, page number 6. That is the soft copy which I have generated from the email.
and what is
That is the
page
last
6?
payment certificate they have asked for, which is page number 6 is the same. And this same hard copy of the same has been dispatched on 7/4. And by during 2 or 3 days, they will be receiving it.
yes, Lordship.
Huh?
That is.
Within 2 or 3 days, they will be receiving it.
We have
Since
not
it was
received it
dispatched on 7/4, 8 on 9 was Saturday, Sunday. Today is the Monday on 10th. I think by tomorrow or day after tomorrow, they will receive it.
As regards area,
Area, we have given the calculation. That is the page number 6. That is the certificate which they have sought for. What was the last payment certificate?
understood, but what is the area you are giving? I will have it on again on 19th. If 19 nothing happens out there, I'm telling you,
Lordship, we
This
will
court is going
forward
to
the
import.
documents to the
No,
Director
no,
of
no.
Pension immediately, Lordship.
absolutely.
Yes, Lordship.
Just
Lordship,
take it from me that this court is going to pass an
No,
order.
no, we have immediately
For-
taken it.
Yes, Lordship.
We have even not yet received the copy
Whatever
of the
means.
writ petition without waiting for anything.
Lord Mr. M. Das, the learned counsel appearing on behalf of the petitioner, Mr. P. N. Sharma appears on behalf of the Elementary Education Department. Mr. S. R. Borua appears for the Director of Pension. Mr. A. Solia appears for the Finance Department, who represents the Treasury Officer Nogao. And Mr. G. Jalan appears on behalf of the newly impleaded respondent number
6, my lord.
6. It has been submitted on behalf of the respondents. Counsels for the respondents that in continuation to the order dated 22/3/2023, steps have been taken so that the petitioner receives her family pension. Full stop. However, there has been certain delay as the original copy of the PPO
Yes.
disbursal slip had to be sent by way of speed post only on 7th of April 2023. List the matter again on 19th of April 2023, on which date the learned counsels for the respondents shall apprise this court as to whether the petitioner have been paid her, shall apprise this court as to whether the family pension have been disbursed to the petitioner. Certain documents have been placed on record by were produced by Mr. G. Jalan during the course of the hearing, which is kept on record and marked with the letter Z.
Lordship, the process of it has to be revalidated by the Director of Pension also, my lord. So it will take some time, my lords, because the Treasury officer will send it back to the Director of Pension, my lords, and then a fresh proposal will have to be issued, my lord.
Okay,
That is,
we'll fix it on 28th of April.
Lordship,
28th of April. So, sir, it is made clear that if in the circumstance the respondent authority, if the petitioner does not receive the disbursal, if the petitioner in the meantime is not disbursed the family pension, then there's this court puts notice upon the respondent authorities as to why interest at the rate of 15% per annum should not be imposed upon jointly and severally upon all the respondent authorities, that is the Director of Pension, the Treasury Officer Nogao, as well as the Chief Manager of the State Bank of India, Roha branch, which shall be realized subsequently by the state departments from the salary of the airing officials.
Okay. 46.
Deeply open.
Yes, oh, this matter.
Yes.
Mr. Sharma, you kindly take instructions in this matter. Unnecessarily, and somebody made the mention about this matter and that he is withdrawing. It's a case of during the suspension period has not been regularized. Na?
Regularized, my lord.
Now, why he has not got, you have not got your pension?
That, my lord, there is no such problem. Everything is clear, regularized. But some conflict in between the petitioner and the earlier superintendent, he already retired, my lord.
Conflict. Now you don't have any problem.
No, my lord, not yet processed, my lord.
Okay. Yes, Mr. Sharma,
Lordship.
you get your instructions. I'm fixing it on 8th of May.
Lordship.
Heard Mr. R. Islam, the learned counsel, appearing on behalf of the petitioner. Mr. Ian Sharma appears on behalf of the director of the which school department?
Secondary.
Huh?
Secondary.
Appears on behalf of the Secondary Education Department, and Mr. S.R. Borua appears on behalf of the Director of Pension. And who appears? Accountant General, anybody?
Respondent number 4, M.
One appears on behalf of the respondent shall obtain instructions as regards the status of the petitioner's pension proposal. As well as the area as claimed in the writ petition. List the
Mat-
matter on
Eight.
8th of May.
Madam,